Check. 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 Check.
Honourable members, Madam Speaker.
Prayer.
Almighty God, who in your infinite wisdom and providential goodness have appointed the offices of leaders and parliaments for the welfare of society and the just government of humanity, we beseech you to look upon with your abundant favor these your servants, whom you have been pleased to call to the performance of such important trusts in this land. Let your blessing descend upon them here assembled, and grant that they may, as in your presence, treat and consider all matters that shall come under their deliberation in so just and faithful a manner as to promote your honor and glory, and to advance the good of those whose interests you've committed to their charge. Amen.
Item 2 on the order paper, communication from the chair.
Honourable members, I want to welcome you to this afternoon sitting. I also want to inform this House that on 2nd Tuesday, September 2025, we had appointments committee. We approved the principal judge pursuant to Article 142(1) of the Constitution of the Republic of Uganda, and members of the Leadership Code Tribunal pursuant to Article 235A of the Constitution of the Republic of Uganda, and in furtherance to Rule 177 of the Rules of Procedure. the committee has communicated to the President the decision of the Appointments Committee. However, Rule 176 of the Rules of Procedure requires that we communicate to the House all the approvals that we have made, because we act on behalf of the House. So those are the approvals that we made on that day. Honorable members, I want to put the Public Accounts Committees on a notice that on 9th September 2025, the House will only be considering reports from accountability committees. And failure to do that, then we'll have to do an omnibus approval. And of course, that will be an indictment to the leadership, you, the acting LOP. That will be an indictment to your leadership and members of the committee. So we'll be handling accountability committees. Honorable members, you're also aware that we always have the East African Games. Trainings have started, and we will be having the East African Games end of the year. And these games help us in widening, tightening, and deepening the integration of East African communities. So if you're a participant, if you're one of them, please go and train, and the selection will be on merit, who is doing very well. Honorable members, I will invoke Rule 26.1 of Rules of Procedure and vary the order paper to accommodate the laying of 2 reports from Auditor General. I want to thank you again for coming and have a fruitful debate. Thank you. Yes, Chairperson Games.
Right, Honourable Speaker, I want to thank you in your capacity as the chairperson of the patron of the Parliamentary Sports Club. On the issue of the games, Right, Honourable Speaker, just to inform colleagues that all the facilities where we are supposed to do training from have been availed to the parliamentary teams. So I want to request that members do report. Officially, we began training on 1st of September, because, Right Honourable Speaker, colleagues were asking whether, given the election cycle, the games will be there. The games will take place. We've participated in these games before, even with the election cycle, and I want to request the colleagues to train very seriously. We have a challenge, Right Honourable Speaker, at the last minute. Members come to the chairperson, they want to be included on the teams. The chairperson does not decide who gets on the teams. It is merit, it is your training, it is your captains and the coaches. And they also come to the patron at the last minute reporting. So the time is now. People should train, they should report for training, because we should be able to defend our trophies that we won in Mombasa last year. I want to thank you, Right Honourable Speaker.
Thank you. Yes, Goretti. Let's first have the minister, your size mate.
Madam Speaker, maybe before I say what I'd wanted, let me take the opportunity on behalf of the people of Ngariam to congratulate you for having been elected as the second national female vice chairperson of the NRM.
Thank you.
Secondly, I also want to go on record and say I thank Parliament and you, Madam Speaker, and the leadership who have just concluded the CHAN 2024. And it was the best competition ever in the history of CHAN as far as CAF is concerned. On a subject matter, Honorable Asuman said, I wanted to give additional information. We did participate.
Honorable Minister, We also want you to bring a tribute motion.
Madam Speaker,
on
most
Chan, because it
obliged.
should be on the record that it was something that was done perfectly and was very good, well organized.
Madam
I
Speaker.
happened to attend the closing ceremony. I was even given a present for the president for having such a game. So we need a motion from you.
Madam Speaker, most obliged. I will request Honorable Suman to second the motion as government. I'll bring it then. I know why I'm saying so, because the chairperson of the Parliamentary Sports Club. But the information I wanted to give him is that some of us colleagues might be fearing to participate because it's a campaign season. I thank God I've been here a bit longer, maybe with the Honorable Mwijiche, who have participated even in this competition and won. So, Madam Speaker, it's just a matter of us encouraging colleagues. It is God which makes us to be here. So don't fear to showcase your talent because you feel you must go and look for votes. The votes are there and we have been looking for votes. Thank you so much.
Thank you. If you've been working for your voters, the voters will vote for you whether you're there or not. Yes.
Thank you, Right Honourable Speaker. In your communication, you requested that the Public Accounts Committee, all of them, COSASI, PAC, and local government, have their reports ready by 9th. Right Honourable Speaker, I want to confirm that we shall have the reports ready and want to thank you for your considered extension of time because these reports were affected, number one, by the NRM primaries.
No, don't talk about NRM primaries.
Right Honourable Speaker.
How?
Honourable Speaker, that is the fact. You know you are the majority on these committees and members were on and off. That is the fact. And I want to appreciate you for extending the time, Right Honourable Speaker.
Okay, can I have the reports in
Right
my
Honourable
office?
Speaker, as I conclude, the reports will be ready by 9th. I want to thank you.
No, can I have them in my office? Because I equally have to read them.
Right
Before
Honourable
that.
Speaker, we shall submit in time.
Thank you. Honourable members, in the public gallery this afternoon, we have students and teachers from Sunshine Christian Primary School from Koboko. All the way from Koboko. They are represented by Honourable Ayume and Honourable Taban Sharifa. You're most welcome. Thank you for coming. Join me in welcoming the youngsters from Koboko. Welcome, please have a seat. And when you're going back, they should not make you move in the night. The teachers, you should not make our children to move in the night. Yes.
Thank you very much, Right Honourable Speaker. Right Honourable Speaker, you have talked about the issue of the children not moving at night.
Hey.
Yes. And Right Honourable Speaker, I recall before
I
we
am
closed.
saying our children should not move in the night, Honourable Minister. Our children should not be transported in trucks, lorry trucks. And they should not be packed like their luggage.
Right Honourable Speaker, thank you very much. But before we closed, remember, Right Honourable Speaker, I had raised the issue. The Ministry of Education and Sports actually issued new guidelines on the issue of children, visits being organized for children. And despite these guidelines, but also other social activities in schools, despite issuing these guidelines, we have seen schools continuing to organize tours for children from long distances, and most of them are return journeys. So, Right Honourable Speaker, the Minister then pledged to bring a statement to update this House on the new guidelines. And I also want to know why, despite these guidelines, the school tours, which are okay, but the long distance tours have continued. So, Right Honourable Speaker, I just wanted to find out why, instructions are issued, guidelines are given, but we still continue to see these And of course, now the year is about to end. The senior 4s, senior 6. You remember that those lavish farewell parties for the senior 4s and senior 6s, there were also guidelines. So, Right Honorable Speaker, can we get an update from the Ministry of Education on these things? Because the other day we saw children getting an accident. I think it was somewhere in Mitiana. Thank you, Right Honorable Speaker.
Thank you, Honorable Minister. There are guidelines that were issued on travels of these children when they are getting out of school, when they should get out of school, and what time they should travel. And some schools seem not to respect that. You need to kind of get away of reprimanding those schools that do not abide by the regulations and by the guidelines that have been issued by the schools. I mean by the ministry. Yes, before the minister comes, Ross.
Thank you so much, Right Honorable Speaker. Right Honorable Speaker, I totally agree with you, but I just take a slight move back on what Honorable Sarah has just said, that children from far distances should not visit. Right Honorable Speaker, most children get motivated to study harder when they come and see wonderful places like this. If you went to Terego, where we do not even have tarmac roads, and we come to Kampala, we see this kind of sophistication, we'll be motivated to come to Makerere University after coming to see. It would be good to say long-distance children like mine.
Did I say they should not travel?
Here. No, I'm saying...
I say they should travel but daytime.
Thank you. That's why I say I totally agree with you. But only
why should we limit these children to come all the way?
Thank you, Right Honorable Speaker.
Honorable Minister.
This is an administrative matter.
I want, Madam Speaker, first of all to thank Honorable Saro Pendi and Honorable MP for Terego, Obiga. It is true, as a Minister of Education and Sports, we did issue a circular to all the districts in the country regarding on-study tours. And in that circular, Madam Speaker, if you permit me, I'll be able to bring it here and lay on table for all of us to help us, Minister of Education, to continue with this communication to that effect. The circular was very clear on even what kind of transport our children should use when they are going for study tours and which kind of study tours. We had even given approvals to be undertaken by the district education officers for purposes of regulating these study tours, because you're also aware that some schools are making it a business. And that's why we said there must be the involvement of the district education officer in terms of clearing whether it is a study tour or it is entertainment tours, name them. Madam Speaker, and I want to reiterate again to our countrymen and women out there, the Ministry of Education and Sport does not stop study tours. The Ministry of Education and Sports guides on how these study tours should be conducted. And that's why now, like for instance, the issue of raised, Madam Speaker, which kind of transport, what time should our children be moving, is one which we have all been able to categorically state in terms of the guidelines, the circular we issued. We expect our children to move morning to evening. We expect the study tour to be cognizant of the mode of accommodation. Our children will be staying in a place where they are going to stay. They should be taken care of it very well. So now, what is happening in the countryside is, Madam Speaker, I want to take it up and also bring in Uganda Police Force to this effect, to work with the police force, security organization in terms of beginning to look at the means and the category of transport they are being used to allow our children to move. For instance, you said, how can you carry children in an open track to Kampala? How can you carry children on a DMC vehicle which is not well maintained? These are entirely things which we want to appeal to all of us to be involved. My colleague, you wanted a clarification, let me give you.
Honorable Minister, you will need to give us a copy of the circular so that each member of parliament will have that copy You are the representatives of the people in your constituencies, and you should be able to give that information to your areas. Yes?
Thank you so much, Right Honourable Speaker. And thank you, Honourable Minister, for giving way. Right Honourable Speaker, some time back again, to do with the Satura, we raised an issue of transportation of children in the morning schools. You find kids being picked at 4 a.m., 3 a.m., and then when you visit schools at 8 a.m., all of them are sleeping in school, in classes. Then you say, why wouldn't they be left to sleep and be picked at 7? So I don't know whether, as you come to give us, to clarify on the Sachuran guidelines, whether you can also talk about the picking of kids in the morning as early as 4 a.m. And taking them late. Thank you.
Honourable members, the people who pick these students, I mean these peoples, leave alone students, peoples, are these people who do business, that you, the parent, goes and hires them. It is not the ministry that does it. It goes back to parenting. Parenting. If you want your child to have a comfortable life, go to school at the time when they are supposed to, don't go for that. Go for a transport, a mode of transport that you're sure of. So we cannot put a blame on the ministry for that. Next item. Look. Members of the matters of national importance will come at the Prime Minister's time. Yes.
Honourable Speaker, I want to thank you for your communication. Number one, to emphasize to colleagues, because you mentioned the Public Accounts Committees, which we are in charge of. I'm in touch with colleagues. They tell me they're expediting the work. My hope, just like your hope, is that they'll finish the work soon. The persons who are offering leadership to these committees are very experienced members of Parliament. In fact, all of them are serving their third term.
No, more than 3.
Yes. All the chairpersons of the Public Accounts Committees are serving their third term. There's a colleague who is saying no. I am there, and I say this with humility. They are supervisors, so I know. But anyhow, the point...
Anyway, it's not about how old you are in the committee.
My point is that... Let me make the point. The point that I was making is...
Susan, leave the lob to speak.
We trust they are doing their work. I'm glad some of the deputy chairpersons are here supporting that process. We hope that work comes through very soon. Honourable Speaker, you did mention again in your communication the Appointments Committee approval of the new principal judge. I saw the learned Deputy Attorney General here. I don't know if he has... Maybe he's around. So I could raise this so that he can give us a bit of guidance. The Honourable Minister of State for Sports at some point was meant to join law school, so he can hold a brief for the Attorney General and brief him. But this is a serious matter, Honourable Speaker, and that's why I had thought it would be good for the learned Deputy Attorney General to be here.
Honourable Lop.
Yes, right.
Can I refer you to Rule 176?
Let me make use of the rules you gave me, my Right Honourable Speaker.
I gave you a gift of rules. The chairperson of the Committee of Appointment shall report to the House any appointment approved by the committee, and the report shall not be subject to debate. Now, those other issues you want to raise should not be subject to what I brought up. It should be something outside what I brought out.
Most obliged, Honourable Speaker. Incidentally, I wasn't planning to open up debate at all. I just wanted to reiterate something that I mentioned yesterday, and you guided that the Attorney General would be here.
He's coming back.
To respond. Maybe when he returns, he will give me chance. So I'm not making reference to the work there, so we can wait for him.
Thank you. Next item.
Item 3 on the order paper, bills first reading.
There's a procedural matter.
Thank you very much, Madam Speaker. I raise on a procedural matter. I'm aware that you've ruled that matters of national importance are going to be raised during the Prime Minister's time. Madam Speaker, this is about life and death. In a sense that my fear is if I'm to wait, I don't know what's going to happen between now and the Prime Minister's time. Madam Speaker, when I took the oath, I swore by the Constitution and the Bible as a practicing Catholic to protect, defend, and preserve the Constitution. Madam Speaker, Article 22 is crystal clear on the right to life. And Article or Chapter 24 is also crystal clear in regard to the freedom from torture, inhumane, and degrading treatment. And lastly, Madam Speaker, Chapter 23 is also clear on the freedom of personal liberty. Madam Speaker, August 19, the RDC of Kasese summoned security, a joint committee of security, to unleash terror on law-abiding and peace-loving citizens. And as a matter of fact, Madam Speaker, September 22nd, the man or a fellow citizen that was brutalized ended up losing life at St. Paul Hospital. And Madam Speaker, the fact is very simple. Government.
So what is the procedure matter?
The procedure matter, Madam Speaker, is the ministers representing government are in the House. These are citizens confronted with the challenge of forceful land evictions, and also, Madam Speaker, that are assembled peacefully at the RDC's courtyard and are being denied their constitutional rights. In a sense that, Madam Speaker, while they are assembled in the RDC's compound, they have been denied the access to food and medication. For the mothers that went to look for food for their children, they've been stopped from even accessing that camp, and as a result, the young babies are starving to death. And Madam Speaker, this is something that this House cannot allow or tolerate to go on. So my prayer, Madam Speaker, procedurally, is that government, this is a known matter even to the President. He sent and sanctioned the Minister for Lands, Minister Mayanja Sam, to go and look into the matter. He made the people camp peacefully in the compound, Madam Speaker, and promised to report back. Nothing has happened, Madam Speaker. The court judgments to the effect that these people should be compensated. Nothing, Madam Speaker, has happened. And as a community where I come from, that is prone. 1 minute, Madam. This is.
Give him a second.
Yes, Madam Speaker. Thank you very much. I don't know who was tampering with the system. But thank you for your kindness, Madam Speaker, and your generosity. Madam Speaker, the people of Kasese are not asking for too much. They're asking for timely justice. As fellow citizens, they deserve the right to live. You can't walk into a camp and deprive somebody their right to live. All lives matter, including the lives of the Kasese people and elsewhere, including, I can say, citizens of the world. So, Madam Speaker, my prayer, government, please fast track this. Fast track this. We want this predicament and matter solved comprehensively. And also, Madam Speaker, compensation be made to the family that lost our fellow citizens in the name of Mr. now deceased Stephen Mohindo Esenge. And Madam Speaker, you will allow me, if this is not handled, I'll continue coming back to this House raising the same matter until this is comprehensively settled by government. Thank you very much.
Honorable members, as community leaders, we need to show leadership in our communities. Because when you look at what Honorable Atkins is raising, he's talking about the matter of his procedure matter, talks about land issues, abuse of human rights, illegal confinement, compensation. But then, what have you done to those people? What have you advised them to do? They must seek redress from somewhere for them to be handled. Anyway, government is here.
Thank you very much, Right Honorable Speaker. And I thank the Honorable Katsabe for raising an issue that affects the people of Kasese. I know there are people in Kasese who have been living in a camp, and the government has been trying to resettle them. I do not know exactly what triggered what he's describing, but I undertake to get in touch with the Katsabe and the RDC and establish the facts. And the Honorable Pendo was helping me to get the information. So, as Parliament sits, I want to get in touch with the Honorable Katsabe and the RDC of Kasese and establish the facts. What exactly triggered that action from the RDC? And the government does not condone disturbing the peace of the people, and appropriate measures will be taken, and then we can update the House. If I get full information, I can even update the House before we conclude the sitting.
Yeah, let him give you all the information, then you can handle it. Honorable Dag is here.
Honorable Speaker, I'm glad you've drawn my attention to the return of the learned Deputy Attorney General. I raised something here yesterday, and you asked me to raise it in the presence of the Attorney General. Yesterday I did lay two rulings regarding two particular prisoners. One, Anthony Agaba versus the state, also known as Bobby Young. Another, Yasin Sechitoleko, also known as Machete versus the state. They applied for bail in the High Court. And court said, look, you are not properly before us. Why? Because your matters have not been transferred from the military courts to the civilian courts as per the ruling of the Supreme Court on 31st January of this year. Now, these people are in limbo. They are in abeyance. And that's problematic for justice because the DPP has not preferred formally charges so that the High Court then takes over. So High Court is saying, we don't know you people. Meanwhile, the military court is funked as official because the Supreme Court said transfer all those files. So we would like to know what exactly is happening. Where do these people go? Because they cannot go back to the military court, which is funked as official. The High Court, which they are running to, is saying, we don't know you. You have not been brought before us formally. And so they are stuck. It's now coming to, 3/4 of a year. What should they do? And I'm saying that in light of now the DPP has even been promoted to principal judge. Hopefully, there will be another DPP soon. What should they do? Maybe guide us, because they keep asking us and their lawyers. We don't know what to tell them. Finally, Right Honourable Speaker, now that Doug is here, he could respond to this as well. We passed the Political Parties and Organizations Amendment Act here. It was passed by this House. Many of us were, of course, bothered by the process. Stakeholder engagement did not happen as should have. But you see, that law is now law. Even as we challenge it in court, wherever and so on, it is existing law until we see what court does say. So that law created two, you can call it departments. One for parties that have no representation in Parliament, the other for parties which are represented here in this House, and they called it IPOD. So by virtue of law, we are all conscripted into IPOD. We are there by force. That's the law anyway, as it is now, until whatever gets to happen to it. Now, the Ministry of Justice and the Attorney General was meant to bring regulations, of course in consultation with the stakeholders, including us, who are in IPOD by force, because that's the law now. The regulations have not happened. We have not been consulted. And yet we hear there is a lot that's happening. There is meant to be an MOU. That MOU is meant to be done in consultation with all the stakeholders. And then the stakeholders are reached out to look at the regulations, to look at the MOU, and either sign or not sign. But that has not happened yet. We don't know if things are happening secretly, because by virtue of law, we are now there by conscription, by force, if you like. What's happening? Will those regulations come? Will that MOU draft be given to the stakeholders so that we look at it and see, is this something we want to be part of? Because you see, we can all be part of something by conscription, but then all stakeholders need to know, okay, what are these regulations saying? Are we okay with them? Are we okay with this MOU? And then we choose to sign or not to sign, but we hear a lot is happening surreptitiously, and even this House, which passed the law, is waiting for those regulations that are meant to give effect to that law. It has not happened. Stakeholders are in the dark. Learned Attorney General, please offer some guidance.
Thank you. Thank you.
Thank you, Right Honourable Speaker. My brother Senyonyi today is shooting on all cylinders. One, the leader of opposition, you've made a reference to a ruling that you tabled yesterday, which I've not yet had the privilege of looking at. But be that as it may, yes, the Supreme Court made a decision, and I have stood on the floor of Parliament before and told you that there are processes ongoing, and I do understand that they may not have moved at the pace that you require them to, but I did pledge here when my brother from Kasese raised the issue of SG. I said these files are moving, give us time. The office of the DPP is working. We pledged as government, as a ministry, because we are bound by the decision of the Supreme Court. We will meet it. Just give us time. On the issue of iPod, we are working on the regulations. Give us the necessary time. They will come. I beg
Thank you. Next.
Land Attorney General, if you could offer some further clarification, because you see, each time you have raised here on the floor, you have said, give us time. It's coming to a year. These people are in jail. In fact, one can even say illegally, because the court which sent them to jail has no jurisdiction over them, the military court. And now the High Court cannot receive them. How much time? So that they know, they plan. I don't know if you've been in jail. I know you have been in the opposition before. I don't know if at that time they did incarcerate you. But for those who have been to jail and you do not know your fate, it's problematic. These people are requesting to know at least a bit of an idea of time. And finally, Honorable Speaker, on the question of iPod, because you've also said give a bit of time, maybe that should also be clarified, because we hear a lot is happening surreptitiously. We've seen some people signing MOUs, and we're saying as stakeholders.
Which people?
We did see a political party.
As a leader, tell us, we've seen DP.
The President and Secretary General of our colleague party, the Forum for Democratic Change, went and signed an MOU. It was in the media and so on, which is okay. That's actually not the issue. The point is, can that be shared with all stakeholders? So that stakeholders look at it and say, okay, I am happy to sign this or not. But you see, you've not given people an opportunity to know what is in this MOU, what's in the regulations. Because as we speak today, iPod is no longer an NGO like it was. It is now a law in place. And we are all in it by conscription, by force. So we are saying, let's look at those regulations and the MOU. Then we determine, can we sign, can we not?
Honorable members, iPod has its headquarters, and if you want to get information, please go and get that information. Where it is contradicting with the law is when you can bring it to the House. Now, please get that information from iPod. If they are forcefully doing you to do it, then you bring it back to the House. Next.
Item 3 on the order paper. Bills first reading. The National Drug and Health Products Authority Bill 2025.
Honorable members, Article 91 of the Constitution of the Republic of Uganda, 1995, and Rule 134 of the Rules of Procedure give authority to government to bring a bill. I now want to invite the Minister of Health to table the bill for the first reading. Honorable Minister.
Thank you so much, Right Honorable Speaker. Before I table the bill, Right Honorable Speaker, allow me to join the rest who have congratulated you for having attained the highest position within our arrangement and our mighty party NRM. Right Honorable Speaker, again, allow me to congratulate your parents for the humble bringing up that has made you to achieve what you have achieved so far. And we expect more. Thank you so much.
Thank you. You have a certificate of financial implication?
Right Honorable Speaker and honorable members, I beg to move that the bill entitled the National Drugs and Health Products Authority Bill 2025 be read the first time, and the certificate of financial implication is here attached. I beg to lay both the bill and the certificate. I beg to lay. Thank you so much.
Thank you, Honorable Minister. Honorable members, pursuant to Rule 135 of the Rules of Procedure, the bill stands referred to the Committee of Health, and I urge them to expedite its process and report back to the House within the parliamentary calendar time.
Item 4 on the order paper.
Laying of papers.
Item 5, laying of papers. Action taken report on resolutions of the House.
No. Special audit reports.
Laying of papers, reports of the Auditor General.
Madam Speaker, I beg to lay on the table a report by the Auditor General on special audit into the alleged misappropriation of funds for the construction of a Kibwa Olympic Memorial Stadium project in Lira District, reference CID stroke PSC stroke 21 of July 2025. I beg to lay.
Thank you. The report is referred to the Committee of Park Kosase.
Madam Speaker, I beg to lay a report by the Auditor General on consolidated value for money audit on selected urban infrastructure projects implemented by the Uganda Support to Municipal Infrastructure Development Additional Financing Program, USMAID AF, participating municipal councils and cities in the financial year 2021-2022 to financial year 2024-2025. I beg to lay.
Thank you. The report is referred to the Committee of Park Central Government. Just a clarification. I know people like picking things. The report on Akibwa is not on the current construction. It is on the previous, before the current contractor took over. So I don't want anybody to go and speak, you know, there's already misappropriation in Akibwa. No, this was before. Pardon?
Madam Speaker, was Akibwa even constructed at that time?
Pardon?
I'm saying that was Akibwa even constructed at that time?
There was an attempt. There was an attempt to construct, but the money was released. That is the money that was being audited. Yes.
Action taken report.
Right Honorable Speaker, on behalf of the Right Honorable Prime Minister, I beg to lay the action taken report on resolutions of the House taken during the fourth session of the 11th Parliament. I beg to lay.
Honorable members, Rule 229 of the Rules of Procedure always requires that whatever is discussed in the House must come back as an action taken report within 60 days, and that will be deposited in the library for us to see what has been done and what is not yet done. And if nothing has taken place, we will revive the issue. Yes, next. Yes, procedure.
Thank you so much, Right Honorable Speaker. Right Honorable Speaker, as you communicated, you only told us that you were varying the order paper so that you could accommodate 2 additional items, which has been done. Item 4, I expected the Minister of Local Government to give us...
Why do you want to do my work, Ethel?
Thank you. It was number 4, and you only told us
Why
you're adding.
are you doing what I'm supposed to do?
Thank you, most obliged.
Next item.
Right Honorable Speaker, Honorable Katsabe had raised an issue. I don't know if they could allow me to...
You will respond when it is Prime Minister's time.
Okay.
Next item.
Item 4 on the order paper. Statement by Minister on the petition of Uganda Local Governments Association and Urban Authorities Association of Uganda on the status of service delivery in local governments.
Government, first down to go, we want your Minister of Local Government.
Right Honorable Speaker, I was moving out to call the Minister of Local Government to be in the House. And I don't call when I am seated in the House.
So can we go to the next item as we wait for the Minister? and tell him the Ulga people are here waiting.
Item 6. Items.
Yes.
Right Honorable Speaker, Rule 120 on the attendance of ministers subjects them to attend at least.
Next item. Next item.
Item 6 on the order paper, Bill second reading, the Valuation Bill 2024.
Honourable members, the Valuation Bill 2024 was read for the first time on 11th February 2025 and referred to the Sectoral Committee on Fiscal Infrastructure. The committee is ready to report. And pursuant to Rule 136(1) of the Rules of Procedure, I want to invite the Minister to move a motion for the second reading. Honourable Minister.
Right Honorable Speaker, I beg to move a motion that the bill entitled the Valuation Bill 2024 be read for the second time. I beg to move.
Is the motion seconded? Seconded by Sir Opendi, by Amos, by the youth, Rugumayo, by another Amos, by Buheshu, by Singiro, Keyot, Barara, Rampara, Basil, Chemonges, Isaac, Isingiro, Kelea, Wilson, Penny, the Vice Chair Anywa, by Uda, by Omara, by Banda, Alanyo, Wakas, Mwijiche, Aru, Emmanuel, Koluo, another Emmanuel. Then we have Mohammadi, Asaba, Rose, Emily, Ntungamo, and then Kalaki, and the senior youth, Honorable Akumo. Would you want to speak to it?
Madam Speaker, the object of the Valuation Bill is provide for the Office of the Chief Government Varua to undertake statutory evaluations, to establish the Institute of Certified Valuers of Uganda and the Council as its governing body, to provide for the membership of the Institute, to regulate practicing valuation, to provide for professional code of ethics for certified valuers and practicing valuers, to provide for reconciliation of valuations, provide for offenses and penalties relating to valuation, to provide for general rules of valuation, including purposes of valuation and valuation standards, to amend the Surveyors Registration Act, CAP 303, and provide for other related matters. Madam Speaker, this bill was presented to the committee, and to inform the debate, I beg that the committee is allowed to present their report in accordance with the rules.
Thank you. Thank you, Honorable Minister. Pursuant to Rule 136(2), I want to invite the chairperson of the committee to give us his report on the Valuation Bill.
Thank you,
Right Honorable Speaker, for giving me this opportunity to present the report of the Committee on Physical Infrastructure on the Valuation Bill 2024. Right Honorable Speaker, I beg to lay on table a copy of the report and the minutes of the meetings that processed the report. I beg to lay.
Thank you.
Right Honorable Speaker, the Valuation Bill 2024 was read for the first time on the 11th of February 2025 and referred to the Committee on Physical Infrastructure for consideration and report to the House. The committee considered the bill in accordance with Rule 135 of the Rules of Procedure of Parliament and hereby reports. The valuation are used to inform decisions in both the private and public sectors, such as real estate and financial markets, infrastructure development, urban development, fiscal regimes, manufacturing and extractive industry, and international trade, among others. Despite this critical role, the valuation function in Uganda is largely limited to land and land developments, with unstreamlined pre- and post-training curriculum, absence of binding practice standards, and an unclear professionalization framework. Right Honorable Speaker, the effect of this is evident in unreliable and unrealistic valuations and inadequate valuation professional practices, which have led to delayed implementation of public investments and infrastructure projects, financial loss, contestation of government valuations, increased litigation against government and hefty court awards, as well as imperfect real estate markets and non-performing loans, among others. The aforementioned problem imply that there is need to properly regulate the valuation function for it to fully contribute to the socio-economic transformation of the country. Right Honorable Speaker, the object of the bill. The object of the bill is, 1, to provide for the Office of the Chief Government Valuer to undertake statutory valuations. Number 2, to establish the Institute of Certified Valuers of Uganda and the Council as its governing body. Number 3, to provide for membership of the Institute. Number 4, to regulate practicing valuation. Number 5, to provide for professional code of ethics for certified valuers and practicing valuers. Number 6, to provide for reconciliation of valuations. Right Honorable Speaker, in the interest of time, I wish to invite members to go through in the methodology the stakeholders that the committee engaged in processing this report. Right Honorable Speaker, let me move straight to the committee analysis, observations, and recommendations. 1, interpretation. The bill in clause 1 defines asset to mean a tangible asset or intangible asset owned or controlled by any person from which past, current, or future economic benefits are expected to flow to the person. The bill also defines property to mean a tangible asset or an intangible asset and includes the interests, rights, and benefits in the tangible asset or intangible asset as the case may be. The committee considered the proposals to define the words asset and property, and it is of the considered opinion that the definitions do not reflect the way the words are used in the bill. Right Honorable Speaker, the use of the words the person in the definition of the word assets leaves a lot of room for interpretation as to the person being referred to in the definition. The committee is concerned that the use of the words the person without specifying which person is being referred to in the definition will create a gray area in the law and will lead to misinterpretation of the provision. The committee was also concerned that the use of the words tangible assets or an intangible asset in the definition of the word asset is redundant, considering that the words tangible asset or intangible asset have been clearly captured in the definition of the word asset. The bill further defines registrar to mean the chief executive officer of the institute. The committee was also concerned that the definition of the word registrar is very restrictive given the fact that the registrar has been given several roles in the bill, including being the secretary to the council. Right Honorable Speaker, the committee recommendation. In light of the above, the committee recommends that Clause 1 stands part of the bill, albeit with amendment to A, expand the definition of the word asset to clarify the person referred to. B, harmonize the definition of the word property with the definition of the word asset. C, broaden the definition of the word registrar. The chief government valuer to undertake statutory valuations. Right Honorable Speaker, Clause 2 of the bill proposes that the office of the chief government valuer in the public service shall undertake statutory valuations and advise government on all matters relating to the practice of valuation. The clause further provides for the valuation for which statutory valuation shall be undertaken for the ministries, departments, or agencies of government on the instruction of government and upon a court order. Right Honorable Speaker, whereas the committee is agreeable to the provision, the committee is of the considered opinion that there is need to clarify the orders of court for which statutory valuation shall be undertaken. To achieve clarity, only court orders that are specifically made to the chief government valuer to carry out valuation should fall under the ambit of statutory valuation. Otherwise, it will be implied that all orders of court requiring valuation to be undertaken should be considered under statutory valuation. The committee recommendation. In light of the above, the committee recommends that Clause 2 stands part of the bill, albeit with amendment to clarify on orders of court for which statutory valuation shall be undertaken. 3. Functions of the Institute. Clause 5 of the bill proposes to make provision for functions of the Institute of Certified Valuers of Uganda. The committee considered the provision, and whereas it is in agreement with the provision, the committee was concerned that the function of the Institute to maintain the standard of the valuation profession in Uganda and the conduct of certified valuers and practicing valuers embodies two separate functions of the Institute into one which will affect its effectiveness and implementation. The committee noted the need to amend the clause to provide for the Institute's function to regulate the conduct of certified valuers and practicing valuers as opposed to maintaining the conduct of certified valuers and practicing valuers. The committee recommendation, Right Honorable Speaker, in light of the above, the committee recommends that Clause 5 stands part of the bill, albeit with the amendment to separately provide for the function of the Institute to maintain the standard of the valuation profession in Uganda and the function of the Institute to regulate the conduct of certified valuers and practicing valuers. Number 4, Right Honorable Speaker, the Council of the Institute. Clause 7 of the bill provides for the Institute to have a governing body called a council whose membership shall include 4 persons who shall be practicing valuers elected by members at a meeting of the Institute. The committee noted that the provision does not specify the years of experience in valuation practice for the 4 practicing valuers. There is need to close this gap in the bill by prescribing the experience of the 4 practicing valuers to have prior to being elected as members of the council in order to ensure that the practicing valuers have credibility and considerable practical insights into matters concerning valuation practice. The committee also noted that whereas the provision proposes that the 4 practicing valuers shall be elected at a meeting of the Institute, there is no clarity on which meeting of the Institute is being referred to in the provision. There is need to clarify that the 4 persons shall be elected at the general meeting of the Institute, which gives an opportunity to members of the Institute to participate in the election of their representatives to the Council. Right Honorable Speaker, the clause also mandates the Minister to appoint the members of the Council, including the President and Vice President, who shall be persons to whom subsection 3A applies. The committee further noted that this proposal raises interpretation issues as to whom the phrase "who shall be persons to whom subsection 3A applies." For purposes of clarity, there is need to specifically mandate the Minister to appoint the President and Vice President who shall be persons to whom subclause 3A applies. The clause further provides for a member who is reappointed to be re-elected by the council. The committee observed that under the clause, the minister appoints the president and vice president from the 4 practicing valuers elected by members at a meeting of the institute. The appointment comes after the election. Secondly, under the provision, the council does not elect members. It is only the 4 practicing valuers who are elected by members at a meeting of the institute. The proposals, hence, if maintained, Right Honorable Speaker, will affect the implementation of the provision. Recommendation. In light of the above, the committee recommends that Clause 7 stands part of the bill, albeit with Amendment 2A, provide a minimum number of years of experience for the 4 practicing valuers who are elected by members at a meeting of the institute. B, provide for the 4 practicing valuers to be elected at a general meeting of the institute. C, provide for the president and vice president of the institute to be appointed by the minister from among the 4 practicing valuers elected by the members of the general meeting of the institute. D, delete the requirements for a member who is reappointed to be re-elected by the council. 5, functions of the council. Right Honorable Speaker, Clause 8 of the bill proposes to make provision for functions of the council. The committee observed that the provision mandates the council to register certified valuers and practicing valuers. However, Clause 41(2) of the bill mandates the institute to have a register of practicing valuers and a register of valuation firms. Under the bill, certified valuers are persons who are entered on the roll of members and only get registered when they become practicing valuers, implying that the bill does not envisage registration of certified valuers. The committee was concerned that the proposal creates a contradiction in the law and will pose challenges in implementation. Recommendation, Right Honorable Speaker. In light of the above, the committee recommends that Clause 8 stands part of the bill, albeit with the amendment to provide for a register of practicing valuers and a register of valuation firms. 6, the seal of the council. Right Honorable Speaker, Clause 9 of the bill proposes to make provision for a seal of the council to be in the custody of the secretary and affixed to any document of the institute. The committee notes that the bill in Clause 4 proposes to establish the Institute of Certified Valuers of Uganda, which shall be a body corporate with perpetual succession and a common seal. The committee was concerned that the corporate status is held by the institute and not the council, hence the proposal for the council to have the seal, and yet the bill mandates the institute to have the seal. This is bound to create a conflict in the law and in the operations of the institute. Recommendation, Right Honorable Speaker. In light of the above, the committee recommends that Clause 9 be deleted with the justification that the provision will result in conflict in the law. 7, termination of office of member of the council. Clause 10 of the bill proposes to make provisions for circumstances where a member of the council chooses to be a member of the council through removal from office or resignation. Whereas the committee is agreeable to the provision, the committee notes that the proposal for a member of the council being removed from office upon conviction of an offense involving moral turpitude is ambiguous. The phrase moral turpitude is incapable of exact definition, therefore the proposal is subject to abuse. The committee also noted that the provision does not include the circumstance where the member of the council chooses to hold office by virtue of which he or she is a member of the council. The committee further observed that some proposed members of the council under Clause 7 of the bill are representatives of institutions, including institutions of higher learning, the ministry responsible for education, and the chief government valuer. Hence, in the event that the said representatives choose to hold their respective offices, they should choose to be members of the council. The committee noted that the provision also includes any other reasonable ground as a ground for which a member of the council shall be removed from office. The committee was concerned that this ground is ambiguous, subject to abuse, and may result in a miscarriage of justice. Recommendation, Right Honorable Speaker. In the light of the above, the committee recommends that Clause 10 stands part of the bill, albeit with the Amendment 2A, remove ambiguity caused by the use of the term moral turpitude, provide for removal of a member of the council where the member of the council chooses to hold the office that he or she represents on the council. C, delete paragraph H with the justification that the provision is ambiguous and hence subject to abuse. 8, registrar. Clause 14 of the bill provides for the registrar, who shall be the chief executive officer of the institute. The committee considered this provision, and whereas it is in agreement with the principle, the committee was concerned that the provision does not effectively provide for the appointment of the registrar. Certain functions of the registrar are missing, and there is no provision for the registrar to resign his or her office. The committee was also concerned that under the provision, the registrar may be removed from office by the council where he or she is declared or becomes insolvent. This ground for removal of the registrar from office contradicts the Insolvency Act, Cap 108, which restricts insolvency proceedings to corporate entities and bankruptcy proceeding to natural persons. The committee noted the need to harmonize the provision with the Insolvency Act, Cap 108. Right Honorable Speaker, the committee further noted that one of the grounds for which a registrar may be removed from office is for inability to perform his or her functions arising from infirmity of body or mind. The committee was concerned that without clear standards or criteria to determine the infirmity of body or mind, this provision is subject to abuse. The committee noted the need for the infirmity of body or mind to be determined by a medical practitioner appointed by the council, as this will allow for an independent medical report by an expert to be issued before a registrar is removed from office by the council for inability to perform his or her functions arising from infirmity of body or mind. Recommendation. The committee recommends that clause 14 stands part of the bill, albeit with amendments to A, provide for the appointment of the registrar, B, provide for additional functions of the registrar, C, provide additional grounds under which the registrar shall choose to hold office, D, harmonize the provision with the Insolvency Act, Cap 108, E, require the removal of a registrar for inability to perform the functions of the office of registrar to be determined by a medical practitioner appointed by the council. 9, funds of the institute. Right Honorable Speaker, clause 16 of the bill provides for funds of the institute, including fees for certificate of licenses for sole practitioners. The committee observed that this provision contradicts clause 24 of the bill, which provides for a certificate of practice for sole practitioner and not a certificate of license for sole practitioner, as this clause proposes. The committee noted the need to harmonize this clause with clause 24 of the bill in order to avoid contradiction in the implementation of the bill. The committee further noted that among the funds of the institute are fines for late application for renewal for a certificate of license or a license to practice. Whereas the committee agrees with the principle, the committee is concerned that the clause is limiting the fines that may be imposed by the institute, which will prevent the institute from imposing fines for any other reason if need arises. Committee recommendation. In light of the above, Right Honorable Speaker, the committee recommends that clause 16 stands part of the bill, albeit with the amendments to A, align paragraph A with clause 24 of the bill, which provides for certificate of practice for sole practitioners and not a certificate of license as proposed in the provision. B, remove the restriction on fines. Number 10, eligibility for members of the institute. Right Honorable Speaker, clause 20 of the bill proposes the criteria for a person to become a member of the institute. The clause proposes the automatic enrollment of a person who is registered as a registered surveyor under the category of valuation under the Surveyors Registration Act as a member of the institute. The clause also proposes for person other than a person referred to in subsection 1 who wishes to be enrolled as a member of the institute to apply to the registrar for enrollment as a member of the institute. Furthermore, the clause provides for the enrollment of the chief government valuer and the valuers in the office of the chief government valuer as members of the institute in accordance with the bill. The committee considered the provision and is of the considered opinion that whereas the provision may have intended for automatic enrollment of the Chief Government Valuer and the valuers in the Office of the Chief Government Valuer as members of the Institute, the use of the words in accordance with this Act causes confusion and implementation challenges. This is because, according to the Act, different persons have different avenues to use for enrollment. There is need to explicitly provide for the automatic enrollment of the Chief Government Valuer and the valuers in the Office of the Chief Government Valuer. The committee further noted the need to provide for an application for enrollment by the Chief Government Valuer and the valuers in the Office of the Chief Government Valuer who do not qualify for automatic enrollment. That is, those who are not registered as registered surveyors under the category of valuation under the Surveyors Registration Act. Currently, the clause proposes that a person who wishes to be enrolled as a member of the Institute shall apply to the registrar for enrollment as a member of the Institute. However, this proposal is not applicable to the Chief Government Valuer and the valuers in the Office of the Chief Government Valuer, because by virtue of being in the Office of the Chief Government Valuer, the valuer must be a member of the Institute. The clause also proposes for applications for enrollment to be made to the registrar. The committee noted that it is prudent to provide for the applications to be made to the council as opposed to the registrar, so that in the event that internal structures of the Institute change and applications have to be made to a different officer, this provision does not hinder the effective implementation of the bill. Furthermore, Right Honourable Speaker, the clause proposes that a person who applies for enrollment shall be eligible for enrollment if he or she has a degree in a discipline or field of valuation or an equivalent qualification recognized by the Council. The committee noted that whereas this proposal is necessary, especially for persons who have acquired academic qualifications in valuation from institutions of learning outside Uganda, the mandate to recognize such qualifications should remain with the National Council for Higher Education. In line with Section 4, Subsection 1 of the Universities and Other Tertiary Institutions Act, CAP 262, which provides as follows: to determine the equivalence of all types of academic and professional qualifications of degrees, diplomas, and certificates obtained elsewhere with those awarded by Ugandan Institution of Higher Education for recognition. Recommendation, Right Honourable Speaker. In light of the above, the committee recommends that Clause 20 stands part of the bill, albeit with amendment. To A, grant automatic enrollment of the Chief Government Valuer, a valuer in the Office of the Chief Government Valuer, and any other person who is registered as a registered surveyor under the category of valuation under the Surveyors Registration Act. B, require the Chief Government Valuer and valuers in the Office of the Chief Government Valuer who are not registered under the Surveyors Registration Act to apply for enrollment as members of the Institute. Require the National Council for Higher Education to equate qualifications of a person who seeks to be enrolled by the Council under Subclause 4. Right Honourable Speaker, enrollment of members of the Institute. Clause 22 of the bill provides for enrollment of members of the Institute. The committee observed that the provision does not specifically provide for an application process for a person who wishes to enroll as a member of the Institute. The recommendation of the committee, in light of the above, the committee recommends that Clause 22 stands part of the bill, albeit with amendment to A, specifically provide for an application process for persons who qualify for the enrollment under Clause 20, subsection 2 and 3. Provide for the enrollment of persons who qualify for enrollment under Clause 20, subsection 1. Delete subclause 5. 12, registration as practicing valuer. Clause 23 provides for registration of person who is enrolled as a member of the Institute and who wishes to practice valuation as a practicing valuer. The recommendation of the committee in this regard is that that Clause 23 stands part of the bill, albeit with amendment to provide for the person appealing to the decision of the Council of the High Court. And then certificate of the practice for sole practitioner. Clause 24 of the bill provides for a person who is registered as a practicing valuer to be granted a certificate of practice for each year of practice on payment of fees prescribed by the regulations made under the Act. In this regard, Right Honourable Speaker, the committee recommendation is that in light of the above, the committee recommends Clause 24 stands part of the bill, albeit with the amendment to A, clearly provide for the process of applying for a certificate of practice for a sole practitioner. B, grant discretion to the Council to grant or not to grant a certificate practice. C, clarity on who appeals to the High Court. D, rearrange the provision in order to enhance clarity. E, exempt the Chief Government Valuer or Valuer in the Office of the Chief Government Valuer from the application of Clause 24. 14, lances practice for valuation firms. Clause 25 of the bill provides for 2 or more persons who are registered valuers and seek to practice as a valuation firm to be granted a license of practice for each year of practice of payment of fees. In regard to this, Right Honourable Speaker, the committee recommendation is that in light of the above, the committee recommends that Clause 25 stands part of the bill, albeit with amendments to A, require the applicant to make an application to the Council and to grant the Council the discretion to grant or not to grant a license of practice. B, delete subclause 3 as a consequential amendment to the proposed amendment in subclause 1. C, require that each applicant is possessed with a certificate of practice prior to applying for a license of practice. D, clarify who makes the application, since at the time of application for license of practice, the 2 or more persons applying for a license for practice are not deemed to be a valuation firm. E, specify the person who makes an appeal to the High Court. 15, temporary certificate of practice. Clause 26 of the bill provides for a temporary certificate of practice for a person who is not ordinarily resident in Uganda but intends to practice valuation in Uganda. The clause provides for a professional valuer not practicing in Uganda, however, intending to practice in Uganda to apply for a temporary certificate of practice within 4 months before arrivals in Uganda. In regard to this, Right Honourable Speaker, the committee recommendation. In light of the above, the committee recommends that Clause 26 stands part of the bill, albeit with the amendment to A, clarify the person being required to apply for or possess a temporary certificate of practice. B, impose a charge of professional misconduct against a person who employs a professionally qualified valuer who does not possess a temporary certificate of practice. Practicing valuation. Clause 25 of the bill proposes to make provision for a person who practices valuation in Uganda to be a person who has a certificate of practice or license of practice. Whereas the committee agrees with the principle, the committee observed that the provision leaves out a temporary certificate of practice issued under Clause 26 of the bill. A person who is issued with temporary certificate of practice under the proposed Clause 26 of the bill is also eligible to practice valuation in Uganda. In this regard, Right Honourable Speaker, committee recommendation. The committee recommends that in light of the above, Clause 27 stands part of the bill, albeit with amendments to A, permit a person who has a temporary certificate of practice issued under Clause 26 to practice valuation. B, exempt the application of subclause 2 to the Chief Government Valuer or a valuer in the Office of the Chief Government Valuer. Enhance the penalty for the offense of practicing valuation without a certificate of practice, temporary certificate of practice, or license of practice. Recommendation. Right Honourable Speaker, disciplinary committee of the Council. Clause 30 of the bill provides for the disciplinary committee of the Council to hear complaints of professional misconduct brought against certified valuers and hear complaints and practicing valuers. The clause provides for the membership of the disciplinary committee, which includes a member of the professional body who shall be a person of good repute. Recommendation. In light of the above, the committee recommends that Clause 30 stands part of the bill, albeit with amendment to include an advocate among the members of the disciplinary committee. 18, reconciliation of valuations. Clause 31 of the bill provides for the Council to appoint a value reconciliation committee to reconcile valuations where 2 or more practicing valuers acting independent of each other render conclusion on evaluation of property with significant differences. In light of this, the committee recommends that Clause 31 stands part of the bill, albeit with amendments to A, provide for an option of appealing the advice of the Value Reconciliation Committee. B, empower the minister to define what amounts to evaluation of a property with significant differences. 19, valuation for tangible and intangible assets. Clause 32 proposes valuation to be undertaken to determine the value of tangible assets, including real property, development property, and plant equipment, and infrastructure, and intangible assets, including business interests, non-financial liabilities, inventories, and financial instruments. Right Honorable Speaker, in light of this, the committee recommends that Clause 32 stands part of the bill, albeit with the amendment to A, delete the listed tangible assets and intangible assets, include any other assets as may be specified by the National Valuation Standard. The valuation report, Clause 34 of the bill proposes a valuation report to be made for every valuation undertaken and should include the name of the certified valuer or practicing valuer who undertakes the valuation, the scope of work performed, the purpose of the valuation, the description of the asset valued, and the valuation date, which shall be the effective date of the valuation. In respect to this, the committee recommends that Clause 34 stands part of the bill, albeit with amendments to A, require a valuation report to indicate the name of the person for whom the valuation is undertaken. B, remove any reference to a certified valuer. C, include valuation principles applied to the valuation in the valuation report. Period of validity of valuation. Clause 35 of the bill proposes to make provision for a statutory valuation assessment made under the Land Acquisition Act for purposes of compulsory acquisition of land by government to be valid for a period of 2 years from the date of the valuation report. The clause further proposes that except for the above-mentioned valuation, a valuation conducted under the Local Government Ratings Act, and valuations whose validity is provided for by the law, any other valuation undertaken shall be valid for the period prescribed by the Minister in consultation with the Council. The committee therefore recommends that Clause 35 stands part of the bill, albeit with the amendment to align subclauses 1, 2, and 4, since the period of validity referred to in subclause 4 only applies to subclause 2. 22. Powers and obligations of certified valuer and practicing valuer. Clause 36 of the bill provides for the powers and obligations of the chief government valuer, other certified valuers and practicing valuers while undertaking valuation. In light of that, Right Honorable Speaker, the committee recommends that Clause 36 stands part of the bill, albeit with the amendment to delete the word certified valuer. Practicing valuer not to act as agents or unqualified persons. Clause 38 of the bill proposes to prohibit a practicing valuer from acting as an agent for any other person other than a certified valuer or practicing valuer in the performance of any act which may only be performed by a certified valuer or a practicing valuer. Right Honorable Speaker, in light of that, the committee recommends that Clause 38 stands part of the bill, albeit with amendments to delete the words certified valuer, or B, provide a penalty for the offense. Practicing valuers not to employ a person removed from the role or suspended. Clause 39 of the bill proposes an offense for a practicing valuer who, in connection with his or her practice, employs or remunerates any person who, to his or her knowledge, is disqualified from practicing as a practicing valuer by reason of the fact that his or her name has been removed from the role as a result of disciplinary proceedings, or because he or she has been suspended from the practicing for a like cause. In light of the above, the committee recommends that Clause 39 stands part of the bill, albeit with the amendment to provide a penalty for the offense. Regulations. Clause 44 of the bill provides for the Minister, in consultation with the Council, to make regulations for the management and use of land valuation management information system. In light of that, Right Honorable Speaker, the committee recommends that Clause 44 stands part of the bill, albeit with the amendment to harmonize the provision with Clause 3 of the bill. Amendment of Cap 306, that's 26. Clause 45 of the bill proposes to amend Section 1 of the Surveyors Registration Act, Cap 303, by deleting the term valuation surveyors, appearing in paragraph H of that section. In light of that, the committee recommends that Clause 45 stands part of the bill, albeit with the amendment to make an accurate reference to the Surveyors Registration Act, Cap 303. General observations, Right Honorable Speaker. The committee made the following observations on matters that are missing in the bill, and yet they are needed to strengthen the bill. The committee observed that some of the words used in the bill are incapable of exact definition if they are not specifically defined in the bill. For instance, the words valuation and valuer are used in the bill but are not defined therein. The failure to define clearly what these words mean will create ambiguity in the law. Recommendations, Right Honorable Speaker. The committee therefore recommends that a provision is made in the bill for the definition of the words valuation and valuer. Right Honourable Speaker, I beg to report.
Thank you so much, Chairman. The bill is straightforward, and Hansard capture the whole report of the bill. We will look at the bill clause by clause, but in the meantime, in the public gallery this afternoon, we have members of the Uganda Local Government Association, ULGA, and Association of Urban Authorities. Where are you? You only two, the other ones are on nominations. They are here to observe the proceedings of the House on their matter. And then we have a group of clerkship students who are attached to the Department of Legal and Compliance Services for internship program in Parliament. Where are you? Welcome. They are here to observe the proceedings. Thank you. We also have students. We will introduce them as we move on. Yes. Members, you've heard the report. We will be amending clause by clause. You have something, Honorable Rugumayo?
Honorable Speaker, I wanted to take this opportunity to make a brief statement just before we go to considering the bill clause by clause. Honorable Speaker, on behalf of all engineers, architects, land valuers, urban planners, and all professions in the School of Built Environment, we wish to extend our gratitude to you and your leadership and the leadership of government at large. For the 11th Parliament has given unprecedented support to the School of Built Environment. Not so long ago,
thank you.
Not so long ago, we had the Physical Planners Registration Act considered here. We had the Engineers Act considered here. Yesterday we had the Building Control Act here. Today we are discussing the valuation bill. For that we say thank you, and thank you to all members of the 11th Parliament.
Thank you, thank you.
However, Right Honourable Speaker, I also want to note and bring this to the attention of the entire House. For example, today we are going to discuss the valuation bill, considering that 3 professions were clustered under one act, the Surveyors Registration Act of 1973. And today we are going to discuss a bill considering one profession. Honourable Speaker, already the Surveyors Registration Act of 1973 is a very old law. It's very outdated, and some of the clauses are outdated. This calls that for government to move so quickly, because by mere enacting of this act, we are going to leave 2 professions unregulated, because they will be left in the old act. I want to call upon government to move quickly and bring forward bills considering the 2 professions. That is the quantity surveyor profession and the land surveyor's profession. The situation cannot be worse, because right now there is some kind of confusion in government. We have the office of the chief government valuer domiciled in the works ministry, and yet the office of the chief government quantity surveyor is domiciled in works, and yet the regulatory body, the registration board, is domiciled in lands. That one causes some bit of confusion in government. So I want to call upon government to quickly propose that bill, but also I want to implore the House that if the bill is brought in time, that we support it. Without which, Right Honourable Speaker, it will leave us with no choice but to move under our rules that guide us this House, and we move as private members, because the laws are very much urgently needed. Thank you very much, Right Honourable Speaker.
Thank you, government. You've heard the concern of the member, government.
Thank you very much, Right Honourable Speaker. Yes, I am a former minister in the Ministry of Lands, Housing and Urban Development, and I know the ministry is reviewing all the laws that fall under that ministry, including the professionals whom the honorable colleague is referring to. So the minister will be bringing bill by bill. So even those old bills are being reviewed so that we can bring them up to date.
Thank you. Where the ministry delays, you can still help the ministry. We are still in one government. Honourable members, you've heard. I put a question that the Evaluation Bill 2024. I put a question that the Evaluation Bill 2024 be read a second time. Those in favour say on the contrary, nay. The ayes have it.
The Evaluation Bill 2024, Bills Committee stage.
Honourable members, we are also happy to have a president of Ecological Party of Uganda. You're most welcome.
Thank you, Madam Chair and Right Honourable Speaker. I can see the Honourable Baryomusi full of smiles. Yes, I look ecological. That's true because I look. Don't go there. Because I'm organic. Don't make me make statements that are not good on this floor of the House. Madam Chair, I would like to congratulate you and many others that went through the various elections and different appointments from their various parties. Now that puts us on a platform where we are all party leaders. And I would like to congratulate the Honorable Baryomunsi for having considered that the elections were tough. The other statements I didn't hear. Having said that he has never seen that kind of money. Madam Chair, from this side we are also worried about the issue of communication, whether it has been made to the Electoral Commission officially about the crossing of members and capturing the data in our records. Because from the Secretariat of IPOD, we got a communication that they await the official communication from you as the presiding officer and from the Electoral Commission. But as far as I'm concerned, from the sitting arrangement, I can see the Honorable Kagabo already donned in yellow and very smartly dressed. Though I'm still willing to persuade him to join the Ecological Party because he says of Uganda that he's willing. So I'd like to also congratulate those that went through the primaries, but those that did not succeed, the father's home here in the Ecological Party still has many rooms. You're welcome.
Thank you. Close one.
Close one.
Chair. Close one. Is interpretation.
Right Honourable Chair, Clause 1 is amended A in the definition of asset by adding the following words at the end of the definition. Who owns or controls the tangible asset or the intangible asset? B, by substituting for the definition of property the following. Property means an asset and includes the interests, rights, or benefits in the asset. C, by substituting for the definition of registrar the following. Registrar means the registrar appointed by the council under section 14. D, by inserting the following definitions immediately after the definition of tangible asset. Valuation means the process of determining the value of an asset. Valuer means a certified valuer or a practicing valuer. Justification: to harmonize the definition of the word asset and property in the context they are used in the bill. To broaden the definition of registrar, since the definition proposed in the bill is restrictive. 3, to define the words valuation and valuer, since they are used numerously in the bill.
Honourable Minister.
Right Honourable Speaker, the amendments are meant to improve the interpretation clause. We totally agree with the committee.
I put a question that clause 1 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 1 as amended.
I put a question that clause 1 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 2.
Chair.
Right Honorable Chair, Clause 2, Chief Government Valuer to undertake statutory valuations. Clause 2 is amended in sub-clause 2C by inserting immediately after the word court the following. C, to the Chief Government Valuer. Justification: to achieve clarity on orders of court for which statutory valuation shall be undertaken.
Yes.
Right Honourable, the chair of the committee has made a correct amendment. Wish to add, however, to insert a new clause in that the persons aggrieved by evaluation opinion of the chief government valuer may appeal for review in a manner prescribed by regulation to this act. Justification: provide an appeal mechanism in case one is not satisfied with the position of the government valuer.
So you okay with the committee?
We're okay.
Okay.
Chair.
Yes.
Thank you, Madam Chair. Madam Chair, I was proposing a new clause, subsection on clause 2, subsection 8, so that we try to empower the government valuer, so that the office of the chief government valuer becomes responsible for all government valuers, officers, undertaking statutory evaluations in the ministries, departments, and also the agencies. New clause in 8.
Chair, that is a useful addition. We agree with the member. That we insert number 8, that the chief government valuer shall be the person responsible for all government land valuation officer affairs.
In all governments. Yes. Chair, it reads that under a new subsection in clause 2, we put subsection 8. Under this act, the office of the chief government valuer shall be responsible for all government valuers and officers undertaking statutory evaluations in ministries, departments, and agencies.
That is a very good addition.
Thank you, Madam Chair. I think the amendment is harmless, but I was wondering whether 2.5 doesn't cover it, where it says where the chief government valuer is not able to undertake a statutory evaluation Because statutory evaluation means evaluation in the government.
Government.
The chief government valuer shall inform the concerned ministry, department, or agency of government.
They are not the same.
No, I know this presupposes
They are
that
not
all
even
evaluation is in the government.
They are not even related.
No, they are.
You rephrase your amendment so that we compare.
The amendment says, under this act, the office of the chief government valuer shall be responsible for all government valuers and officers undertaking statutory valuations in ministries, departments, and agencies. It's mainly to avoid governmental departments to hire private valuers to do assessments of valuation, yet there is an appointment government valuer to do that.
5 is on assignment that a chief government valuer can assign, just like accountants, where you find auditor general assigning another audit firm to audit on their own behalf.
Like
but then the 8 is talking about gives primacy to the government chief valuer.
I think his amendment is okay, but I was just looking at 2.1, which say the office of the chief government valuer in existence in the public service shall undertake the statutory evaluations. I thought this means that all evaluations in the government shall be undertaken by the chief government valuer. The Auditor General does, like that. But maybe for clarity, we can adopt it, but I thought it's the same as number 1.
One does not give him this primacy, one gives it is on advice. Shall give advice.
No, shall undertake the statutory evaluation.
Evaluation and shall advise the government. That is 1. That is 1. The amendment is useful to a certain extent.
Honorable Chair, we are okay with the amendment. It's only that the last clause in ministries, departments, and agencies may not be necessary because statutory evaluations is adequate. It means it's in government.
Okay. Yeah. I put a question that clause 2 be amended as proposed by the committee and further amended by Honorable Isaac Otimugui and the Minister, Honorable Magesi. Those in favor say, and the contrary, nay. The ayes have it.
Clause 2 as amended.
I put a question that clause 2 as amended stands part of the bill. Those in favor say, and the contrary, nay. The ayes have it.
Clause 3.
I put a question that clause 3 stands part of the bill. Those in favor say, and the contrary, nay. The ayes have it.
Clause 4.
Clause 4.
Right Honourable Speaker, there is a proposal to insert a clause to deal with the appeal mechanisms. Appeal mechanism for statutory valuations.
Go ahead.
So the proposal is that persons aggrieved by valuation opinion of the chief government valuer may appeal for review in a manner prescribed by regulations to this act.
And the justification? Justification?
Chair, I understand Doug's concern, but I thought I brought that one under clause 2. That's where it fits. Because clause 4 is about the institute of certified valuers.
It will come before 4. Okay. It is a new insertion that he is talking about, yes.
Right Honourable, the justification is that no appeal mechanism for statutory evaluations had been provided.
I put a question that a new insertion stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 4.
I put a question that clause 4 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 5.
5, Chair.
Right Honorable Chair, Clause 5 is amended A, in paragraph A, by deleting the words and the conduct of certified valuers and practicing valuers. B, by inserting immediately after paragraph A the following: regulate the conduct of certified valuers and practicing valuers. Justification: to split paragraph A into two provisions in order to separately provide for the functions of maintaining the standard of valuation and the regulation of the conduct of certified valuers and practicing valuers.
Chair, we agree with the amendment.
I put a question that clause 5 be amended as proposed. Those in favor say and the contrary nay. The ayes have it.
Clause 5 as amended.
I put a question that clause 5 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 6.
I put a question that clause 6 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
New clause.
New clause.
Right Honorable Chair, insertion of new clause immediately after clause 6. The bill is amended by inserting immediately after clause 6 the following: seal of institute. 1. The institute shall have a seal which shall be in the custody of the secretary to the council, and which shall, by the order of the council, be affixed to any document of the institute. 2. The seal of the institute shall be authenticated, A, by the signature of the president and the secretary to the council. B, in the absence of the president, by the signature of the vice president and the secretary to the council. And C, in the absence of the vice president, by the signature of the member acting as president and the secretary to the council. Right Honorable Chair, justification: to harmonize clause 4, subsection 2, and clause 9 of the bill, since the corporate status is had by the institute and not by the council.
Minister.
Right Honorable Chair, the proposed amendment is in line with the best practice of having the seal with the institute instead of the council. We agree with the member.
Doug.
Right Honorable, I'm in agreement.
Okay, I put a question that the proposed new clause stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 7.
Chair.
Right Honorable Chair, clause 7 is amended A in subclause 3 by substituting for paragraph A the following: 4 persons who shall be practicing valuers with at least 7 years of experience in valuation practice, elected by members of the institute at a general meeting of the institute. B, by substituting for subclause 5 the following: the minister shall appoint the president and the vice president from among persons elected under subsection 3A. C, by deleting subclause 7. Justification: the amendment proposed to paragraph A is to require the members of the council to have experience in valuation practice and to provide for the election of members of the council to be done at a general meeting of the institute. The amendment of subclause 5 is to achieve clarity. Then the deletion of subclause 7 is to remove a redundant provision.
Thank you. So you're saying subclause 5, the minister shall appoint a member of the council, including the president and vice president. Are you retaining that? Are you retaining that? Why are you giving the minister too much powers? To appoint a president and a vice?
Right,
Why
Honorable.
don't you be like other professional bodies like accountants and what, where they will get their
Right, Honorable.
leader?
Chair, we concede to that. We can take that away.
Redraft for me. Honorable Musasi.
Madam Chairperson, I want to, through the chair.
Let's first have amendment of what my proposal.
Madam Chairperson, the chairperson, I'm a member of this committee, and what the chairperson is saying is that the minister shall appoint the president and the vice president from among persons elected. So already persons have been elected, and the minister is only appointing after the election.
Why don't they elect themselves? Why are you saying the minister should?
No, it's appointing after the election.
Okay, let me give you some information.
Okay.
Here. Madam Chair, in the Accountants Act of 2013, we drafted it like this. The president and the vice president shall be elected by members of the council
From within.
from among themselves,
Yes.
in accordance with regulations made under this act.
Yeah.
And this is a very, very good proposal,
Yes.
which can replace subsection 5.
Thank you. I put a question that clause 7 be amended as proposed by the committee and further amended by Honorable Musasi. Those in favor say and the contrary nay. The ayes have it.
Clause 7 as amended.
I put a question that clause 7 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 8.
Clause 8.
Right, Honorable Chair. Clause 8 is amended by substituting for paragraph B the following. Registered practicing valuers and valuation firms. Justification. To align the provision with clause 41, subsection 2 of the bill, which provides for a register of practicing valuers and a register of valuation firms only. The bill does not provide for a register of certified valuers, making the reference to such a register in paragraph B redundant.
Minister.
Right Honourable Chair, we beg to retain the bill as it is, that is register certified valuers, practicing valuers, and I beg to add and valuation firms to cater for the committee's concern. This is because you get a certificate, you enroll under the first phase, then you get a practicing certificate, and then you also have the firms. You can practice as an individual or as a firm. So we beg that we retain the clause as it is, but enhance it in order to bring on board the committee's proposal. That is, register certified valuers, the practicing valuers, and the valuation firms.
So you want it to remain as it is in the bill with a small modification of valuation firms?
Yes, Chair.
Yes. Yeah. Yes, Chair.
Right, Honorable Chair. We agree and concede to that.
Because certification is done by the professional body, so it must be there. Yes, Doug?
I'm in agreement with the minister's position.
Thank you. I put a question that clause 8 be amended as proposed by the minister. Those in favor say and the contrary nay. The ayes have it.
Clause 8 as amended.
I put a question that clause 8 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 9.
Right Honorable Chair, delete clause 9, justification, consequential amendment arising from the insertion of a new clause immediately after clause 6, providing for a seal of the Institute as required in clause 4.2.
Yes, Minister.
We agree with the committee.
Thank you. I put a question that clause 9 be deleted as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 10.
Clause 10.
Right Honorable Chair, clause 10 is amended in sub-clause 2. A, by substituting for paragraph F the following. Upon conviction for an offense by a competent court in Uganda or elsewhere and sentenced to a term of imprisonment for 6 months or more without the option of a fine. B, by inserting immediately after paragraph G the following. Where the member of the council chooses to hold the office by virtue of which he or she is a member of the council. C, by deleting paragraph H. Justification. To remove ambiguity caused by the use of the term moral turpitude, since the word is incapable of exact definition. To provide for where a member of the council chooses to hold the office that he or she represents on the council. Paragraph H is ambiguous and subject to abuse.
Minister.
Right Honorable Chair, we agree with the committee.
Doug.
I'm in agreement, Right Honorable.
I put a question that clause 10 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 10 as amended.
I put a question that clause 10 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 11.
I put a question that clause 11 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 12.
I put a question that clause 12 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 13.
I put a question that clause 13 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it. I was going to tell you to go away.
Clause 14.
Clause 14.
Right Honorable Chair, clause 14 is substituted for the following. 14, registrar. 1, the registrar shall be appointed by the council and shall hold office in accordance with the terms and conditions as the council shall determine. 2, the registrar shall be the chief executive officer of the institute and a full-time employee of the institute. 3, the registrar shall be the registrar of certified valuers, practicing valuers and valuation firms, and shall A, keep and maintain a roll of members of the institute who are enrolled under section 22, a register of practicing valuers, and a register of valuation firms. B, make necessary alterations and corrections in the roll of members of the institute and in any register kept and maintained under this act in relation to any entry as may be directed by the council. C, remove from the roll of members of the institute and any register kept and maintained under this act. 1, the name of any person ordered to be removed from the roll or register under this act. 2, the name of a certified valuer or practicing valuer who is deceased. 3, any entry which may have been incorrectly or fraudulently made in the roll of members of the institute or any register, or the name of the practicing valuer who chooses to practice. 4, the registrar shall be the secretary to the council and shall be responsible for A, recording the minutes of meetings of the council and its committees, and B, keeping custody of all records and documents of the council. 5, the registrar shall cease to hold office if the registrar resigns his or her office, or if the registrar is removed from the office by the council. For abuse of office, for inability to perform his or her functions arising from infirmity of body or mind as determined by a medical practitioner appointed by the council. For incompetence, for misbehavior or misconduct, or where the registrar is declared bankrupt or has made an arrangement with his or her creditors, or where the registrar is convicted of an offense and sentenced to imprisonment for 6 months or more without the option of a fine. Right Honorable Chair, justification. To clarify on the appointment of the registrar, to provide for additional functions of the registrar, to provide additional grounds under which the registrar shall cease to hold office, to harmonize the provision with the Insolvency Act, Cap 108, which restricts insolvency proceedings to corporate entities and bankruptcy proceeding to natural persons, to require the removal of a registrar for inability to perform the functions of the office of registrar, to be determined by a medical practitioner appointed by the council.
Chair, on 3C2, the name of a certified valuer or a practicing valuer who is deceased. Wouldn't it be good for us to add a evaluation firm that has ceased to exist?
Honorable Chair, I entirely agree with that.
Minister.
Thank you, Right Honorable Chair. I fully agree with the committee and your improvement of that.
No, it is yours. You own it.
Yeah, Right Honorable, we beg under C2, the name of the certified valuer or practicing valuer who is ceased, and the firm that has also ceased to exist.
Yes. Because we have introduced a firm, valuation firm. Yes. Yes.
Yeah, thank you, Chair. I would like to propose an amendment in that clause that talks about the council appointing a medical practitioner in grounds where there is a problem with the registrar having infirmity. If you look at the Constitution, there's a provision for the Director General of Health Services. So the council, in consultation with the Director General of Health Services, because there's no medical specialist in the composition of the council. Thank you. I'm proposing that the council, in collaboration
which
with...
clause? Which clause?
It's under the grounds for removal of the registrar on a medical basis. Clause 14. Yeah. No. The clause is saying it's the council that appoints the medical practitioner. But I would like to amend that in consultation with the Director General of Health Services, consistent with the constitutional provision for removal of medical, in collaboration with, because the council that cannot constitute or appoint a medical practitioner, they do not have the professional competence, in collaboration with.
Right Honorable Chair, the Honorable Member makes a very useful amendment proposal, but in my mind I'm wondering whether constitutionally it's not the mandate of the Director General. So we should have actually said as determined by the Director General of Medical Services.
Yes.
Yeah, thank you.
Not appointed by the council. Yes. So we will make that amendment.
Yeah, by the Director General Medical Services or his or her representative.
Yes.
Thank you.
I put a question that clause 14 be amended as proposed by the committee and further amended by the minister. Those and the Honorable Boka. Those in favor say and the contrary nay. The ayes have it.
Clause 14 as
I
amended.
put a question that clause 14 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 15.
I put a question that clause 15 stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 16.
Chair.
Right Honorable Chair, clause 16 is amended A in paragraph A by substituting for the words certificate of license the words certificate of practice. B in paragraph B by deleting the words for late application for renewal for a certificate of license or a license to practice. Justification: to align paragraph A with clause 24 of the bill, which provides for certificate of practice for sole practitioners and not a certificate of license as proposed in the provision. To remove the restriction on fines under paragraph B, since the institute can impose other fines for which the fees arising from such fines constitute funds of the institute.
Minister.
Thank you, Right Honorable Chair. We beg to leave it as it is, with the justification that the firms require a license, whereas the practitioner requires a certificate of practice. So it's important that we leave this clear as provided in the bill.
Doug?
Right Honorable, I take the position of the Honorable Minister.
Concede.
Right Honorable Chair, I concede.
I put a question that clause 16 stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 17.
I put a question that clause 17 stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 18.
I put a question that clause 18 stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 19.
I put a question that clause 19 stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 20.
Clause 20.
Right Honorable Chair, clause 20 is amended A in subclause 1 by inserting immediately before the words a person, the words the chief government valuer, a valuer in the office of the chief government valuer, and by substituting for the words shall be enrolled as a member of the institute under this act, the words is enrolled as a member of the institute. 3, in subclause 2, by substituting for the word registrar, the word council. 4, by substituting for subclause 3, the following: the chief government valuer or a valuer in the office of the chief government valuer who does not qualify for enrollment as a member of the institute under subsection 1 shall apply to the council for enrollment as a member of the institute. 5, in subclause 4, by substituting for the phrase subsection 2, the phrase subsections 2 and 3. 2, in paragraph A, by substituting for the words recognized by the council, the words as may be determined by the National Council for Higher Education. 6, by substituting for subclause 5 the following: a person shall, before applying for enrollment under this section, A, work under the supervision of a practicing valuer for at least 1 year, B, undertake professional qualification training and pass the professional qualification training examinations conducted by the Institute. 7, by substituting for subclause 6 the following. 6, notwithstanding subsection 5, the Council may, upon satisfactory evaluation of the academic qualifications and experience of a person referred to in subsection 4b, exempt the person from undertaking the professional qualification training and examinations referred to in subsections 5. Right Honorable Chair, justification. To grant automatic enrollment to the Chief Government Valuer, a valuer in the office of the Chief Government Valuer, and any person who is registered as a registered surveyor under the category of valuation under the Surveyors Registration Act. To require the Chief Government Valuer and valuers in the office of the Chief Government Valuer who are not registered under the Surveyors Registration Act to apply for enrollment as members of the Institute. To require the National Council for Higher Education to equate the qualifications of a person who seeks to be enrolled by the Council under subclause 4A, since it is the national body responsible for equating academic qualifications. For clarity, to require the conditions set out in subclause 5 to be complied with before a person applies for enrollment as a member of the Institute. To remove the exemption granted to a person who is employed in the public service as a valuation officer from undertaking professional qualifications training and exams, since the exams are necessary to determine the competence of a person to offer valuation services.
Yes, Honorable.
Yes, Chair, I need more clarification on the proposed amendment on clause 24. When they say the Chief Government Valuer or value of the Office of the Chief Government Valuer who does not qualify for enrollment as a member of the Institute under subsection 1 shall apply to the Council for enrollment. I think that this statement is self-defeating, Chair, because if you do not qualify, then you don't qualify. So what is the issue with applying again to the Council if you don't qualify under subsection 1?
Yes. Can you make a clarification first on that? No, let him clarify one first.
Honorable Chair, like the Honorable Member noted, in our amendment we had stated here that the Chief Government Valuer or a valuer in the office of the Chief Government Valuer who does not qualify for enrollment as a member of the Institute under subsection 1 shall apply for the Council for enrollment as a member of the Institute. I think given his point, he has made a critical submission. I think we need to consider his proposal for amendment.
Chair, why are we losing out section 3, the original section 3 in the bill? They are not the same. What you're losing out, notwithstanding section 2, the Chief Government Valuer and the valuers in the office of the Chief Government Valuer shall be enrolled as a matter of, as members of the Institute in accordance with this Act. You're removing that.
Right Honorable Chair, the committee seems to put us in a real difficult situation. If the Chief Government Valuer or a valuer in the Chief Government Valuer's office does not qualify, then how can you say you apply to Council for enrollment? So I beg that we retain the original version.
We don't need an equivalent in this profession.
Right Honourable Speaker, I want to concur with the Honourable Minister for Local Government that we are opening a Pandora's box and distorting this clause. I humbly pray that we maintain the clause as it is.
Yes. So, yes, youth, it's okay?
Chair, I really want also to support Doug's proposal because there are several amendments that the committee intended to propose are already catered for by the clauses that are in here. For example, where they proposed before a person to add there the chief government valuer and the valuer in the government, it is already catered for all rounds because at the commencement of this act, when they say all people who are already registered under the Surveyors Registration Act should automatically be certified valuers. Now, when you go back and add those details, you're just attempting to rephrase and paraphrase, but the clause already caters for all the gaps that the committee had envisioned. Thank you.
Thank you. Honorable Minister, are you okay with all the other amendments apart from that?
Right, Honorable Chair, I'm okay with the bill as it was, except where the committee points out under 4A, a person to whom subsection 2 applies shall be eligible for enrollment if she, A, has a degree in a discipline or field of valuation or an equivalent qualification recognized by council. I think he's right. It should be by the Council for Higher Education.
Yes.
The rest, I beg, remains as it was.
The rest remain as it is in the bill with the amendment that you've moved. I put a question that clause 20 be amended as proposed by the Honorable Minister. Those in favor say on the contrary, nay. The ayes have it.
Clause 20 as amended.
I put a question that clause 20 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it. Honorable members, in the public gallery we have pupils and teachers from Forest View Primary School in Buko. Buko. Stand up and we see you. You're most welcome. They are represented by Honorable Chelengat Solomon Alinga and Honorable Evelyn Chemtai. In the absence, Honorable Chemonges, you stand up and wave at the kids. You're most welcome. Thank you for coming. Thank you. They are here to observe the proceedings. Thank you.
Clause 21.
I put a question that clause 21 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 22.
Clause 22.
Right Honorable Chair, clause 22 is amended A by substituting for subclause 1 the following. A person who qualifies for enrollment as a member of the institute under section 20, subsection 2 and 3 shall, upon payment of the enrollment fees and in a manner prescribed by regulations made under this act, apply to the council to have his or her name entered on the roll of members of the institute. B, by inserting immediately after subclause 1 the following. A person who qualifies for enrollment as a member of the institute under section 21 shall have his or her name entered on the roll of members of the institute without application for enrollment and shall be issued with a certificate of enrollment by the registrar. C, by substituting for subclause 2 the following. The council shall, if satisfied that the person who makes an application for enrollment under subsection 1 is eligible for enrollment as a member of the institute, enter the person's name on the roll of members of the institute and issue a certificate of enrollment to the person. D, by deleting subclause 5. Right Honorable Chair, justification to specifically provide for an application process for persons who qualify for enrollment under section 20, subsection 2 and 3, to provide for the enrollment of persons who qualify for enrollment under clause 21. The deletion of subclause 5 is for purposes of removing a redundant provision.
Can you be enrolled without having an application for enrollment? Read this. A person who qualifies for enrollment as a member of the institute under section 21 shall have his or her name entered on the roll of members of the institute without application for enrollment, and shall be issued with a certificate of enrollment by the registrar. Accountants. If I have not applied, how do you give me a certificate?
Madam Chair, after going through the professional qualification and you have fully qualified, you are supposed to enter another stage of becoming a member.
Yes.
If you want to be a member, you apply,
Yes.
to be a member.
Yes.
And then they assess you.
Yes.
And they admit you as a member. It shouldn't be automatic. You have seen even those who have been practicing before this act comes into force. This law is carrying them. We are also defining their status. So I want to invite the chair to reconsider his position.
It's just like one after going to a law school, you think you are an advocate.
And also too, Madam Chair, since I am on the floor, sub-clause 5, a person appointed in the service of the office of the chief government valuer shall be a certified valuer in accordance with this act. Madam Chair, there is an intention for this clause, for this sub-clause. So I want to plead with the chairperson that this clause, this sub-clause be maintained. There is a reason why it is there. You don't just say delete it.
Yes. Yes, Honorable Rugumai.
Chair, in support of the Honorable Minister's submission.
Or in support of my...
in support of yours. Chair, the proposal by the committee is self-defeating in a way that in the previous clause 20, we had already provided for an application process. At 22, even though subsection 1 is a bit says the person shall be entered on the enrollment, the one who drafted already had in mind that at a previous clause, application had been catered for. I don't think there is any professional body that would allow someone to automatically be part of the system without going through an assessment system.
Thank you.
Thank you.
But you know, this is always a source of revenue for such a body, for the institute. When you apply, you pay a fee and you're registered. So can we retain in the clause 22 as it is? As it is, Chair?
Honorable Chair, we appreciate the need for an application to be made in the second level. So we concede to that, right?
Thank you. Chair? I put a question that clause 22 stands part of the bill. Those in favor send the contrary nay. The ayes have it.
Clause 23.
Chair.
Clause 23 is amended by substituting for subclause 5 the following. A person who is not registered by the council in subsection 4 may, within 21 days after receipt of the decision of the council, appeal to the High Court. Justification. The amendment to subclause 5 is for clarity and better drafting.
What is the difference with what we have in the bill? Chair, what is the difference? I mean, Doug. An appeal to High
Right.
Court shall be made within 21 days after receipt of the decision of the Council.
Right, Honorable, we have created an insertion on clause 4 to provide for appeal. There is an insertion on clause 4. Says a person aggrieved by valuation opinion.
That was on valuation. This is on registration.
Okay.
They are different.
Okay.
Mhm.
Chair, maybe to elaborate more on what principles are espoused in this principle. One is the 23(4) says, as the council communicates its rejection, it gives the it informs the member of his right to appeal. And 5 just goes ahead to say an appeal should be made within 21 days. So I don't see anything
Why
new.
don't we keep it as it is?
Yeah, it should remain as it is.
Yes.
I find it. Okay.
Chair, look at the subheading of that section. It's about registration.
Yes.
And we are saying an appeal to the High Court shall be made within 21 days after receipt of the decision. So
Of the
I don't see
council.
what the committee is really adding.
Okay, I put a question that clause 23 stands part of the bill. Those in favor send the contrary nay. The ayes have it.
Clause 24.
24.
Right, Honorable Chair. For clause 24, there is a substitute. We substitute the following: certificate of practice for sole practitioner. 1. A person who is registered as a practicing valuer shall, upon payment of fees and in a manner prescribed by regulations made under this Act, annually apply to the Council for a certificate of practice. 2. The
So
Council.
you now see the contradiction we have here with what you had before.
Yes. 2. The Council may, upon receipt of the application under subsection 1, grant or refuse to grant the application a certificate of practice. Where the Council refuses to grant the applicant a certificate of practice, the Council shall, within 30 days, inform the applicant of the decision and the reason for the decision. An applicant who is not granted a certificate of practice may, within 21 days, after receipt of the decision of the Council, appeal to the High Court. 5. A certificate of practice shall be valid for the year of issue and shall in all cases expire on the 31st day of December of the year in which it was issued. 6. A practicing valuer who wishes to renew his or her certificate of practice shall, by the 31st day of October of the year of issue, on payment of fees for renewal, as may be prescribed by regulations made under this Act, apply to the Council for renewal of the certificate of practice. 7. A practicing valuer who makes an application under subsection 7 shall accumulate the hours of continuous professional development as may be prescribed by regulations made under the Act. 8. A practicing valuer who is issued with a certificate of practice shall have a practice stamp with his or her name on the trade name and his or her profession, and shall affix the stamp to all documents signed by him or her. 9. This section shall not apply to the chief valuer or valuer in the office of the chief government valuer. Right Honorable Chair, justification: to clearly provide for the process of applying for a certificate of practice for a sole practitioner. 2. To grant discretion to the Council to grant or not to grant a certificate of practice. 3. To clarify who appeals to the High Court. 4. To rearrange the provision in order to enhance clarity. 5. The exemption of chief government valuer or a valuer in the office of the chief government valuer from the application of clause 24 is to harmonize the provision with clause 2, which mandates the office of the chief government valuer to undertake statutory valuations.
So you're repressing the whole of 24?
Right Honorable Chair, we've looked at the proposed amendments. The only addition seems to be details which are supposed to be in the regulation.
Regulations.
So I really request that the chair allows that we maintain.
Because even in the title it says a certificate of practice for a sole practitioner. So it's self-speaking.
Madam Speaker, the proposal made by Madam Chair, sorry, the proposal made by the chair of the committee is in a way a redraft of the same clause, but in a different way.
Thank you.
I would pray that we maintain the clause as it is.
Chair.
Honorable Chair, we concede.
I put a question that clause 24 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it. Honourable members, when you're drafting these bills, please consider what has been the intention of the whole bill.
Clause 25.
25. Chair.
Right Honorable Chair, Clause 25 is amended A by substituting for Clause 1 the following. Subsection 1, where two or more persons who are registered as practicing valuers under Section 23 seek to practice as a valuation firm. The person shall, for each year of practice on payment of fees, may be prescribed by regulations made under this Act, apply to the Council for allowances of practice for the valuation firm. B, by deleting sub-clause 3. C, by substituting for sub-clause 4 the following. For each of the persons who seek to practice as valuation firm shall, before making an application under subsection 1.
Did you say you're deleting subsection 3? First read what you're deleting.
That is B, by deleting sub-clause 3.
Read the 3 that you're proposing to delete. For purposes of subsection 1, the valuation firm shall make an application for a license of practice to the registrar. Why are you deleting it?
Right Honorable Chair, for B, I think we maintain it as it is. Yeah, for 3. Yes. We maintain. We maintain that one.
Right Honorable Chair.
And the justification. Amendment to subclause 1 are intended to require the applicant to make an application to the council to grant the council the discretion of, or grant, to grant or not to grant.
Let's first go back to 4. You're saying by substituting subclause 4 the following. Now, the original 4 is for avoidance of doubt. Each of the partners of the valuation firm shall have a certificate of practice granted under Section 24. So you're not substituting 4. Leave 4 as it is.
Madam Chairperson, if it pleases the House and the Chair and the committee, the Chair of the committee and members, Clause 25 is well intentioned and well drafted. I want to persuade the Chair to withdraw his proposed amendments to this clause and we maintain it. Chair of the committee.
Chair of the committee, not me.
I concede.
Thank you. I put a question that clause 25 stands part of the bill. Those in favor say and the contrary nay. The ayes have it. I think you had a very lazy legal person drafting. I need to know that legal person. Chair, have you heard? I need to know the legal person.
Clause 26.
26.
Right Honorable Chair, Clause 26 is amended A by substituting for subclause 6 the following. The person referred to in subsection 1 shall apply to the Council for a temporary certificate of practice within 4 months before arriving in Uganda. B, by substituting for subclause 7 the following. A firm, entity, or organization, private or public, shall not recruit a person referred to in subsection 1 unless the person has obtained a temporary certificate of practice issued in accordance with this section. C, by inserting immediately after subclause 7 the following. A firm, entity, or organization, private or public, which contravenes subsection 7 commits an offense of professional misconduct and shall be subject to disciplinary measures imposed under the Professional Code of Ethics for certified valuers and practicing valuers. Right Honorable Chair, justification. Subclauses 6 and 7 are amended to enhance the clarity as to the person being required to apply for or possess a temporary certificate of practice. 2, to enhance compliance with the provisions of the section by imposing a charge of professional misconduct against a person who employs a professionally qualified valuer who does not possess a temporary certificate of practice.
By substituting the subclause 6. You read for us 6? Read what 6 is in the bill. Subject subsection 1, a professional valuer not practicing in Uganda, however, intending to practice in Uganda shall apply for a temporary certificate of practice within 4 months before the arrival in Uganda. Yes, Doug.
Madam Chair, I want to strongly differ from the committee chairperson's position and proposes that we maintain subclause 6 with a small amendment, removing the word before arrival.
Yes, before arrival.
This person, the valuer, could have traveled here and be doing A, B, C, D, then he files his application. If we maintain subclause 6 as it is, saying before, it means he cannot land in our country until he has applied.
Yes.
Yes.
Madam Chair. Madam Chair. Madam Chair. Madam Chair.
Daga, you wanted to remove before.
Right Honorable, I wanted to remove the 2 words before arrival.
What is the harm of keeping it?
If we keep it as it is, it means this person intending to practice in Uganda must only apply when he is out of the country. When he's here, he cannot apply. But he could be here He's a foreigner here doing other businesses who now wishes to practice as a valuer.
Madam Chair, I agree with the Attorney General, because when you look at the person we're referring to, it could even be a Ugandan who lives in the UK and is a valuer and intends to come back and practice valuation. So why do you lock him to remain there until he gets certificate? He could come and the application is processed. It's only when it is issued that he starts practicing. So I think the way it is drafted, it means you lock somebody out for 4 months until he arrives, and yet he could be in the country doing other things. So I agree with the Attorney
Minister.
Thank you, Right Honourable Chair. Right Honourable Chair, we should take this section in its entirety. We're talking about under number 1, where a person satisfies counsel that he or she is not ordinary resident in Uganda. It already defines that. That's why under 6, we say subject to subsection 1. So for me, if we say we don't need 4 months before arrival in Uganda, then delete the whole thing of within 4 months. Just say you apply for a temporary certificate. That would be adequate. Yeah.
Okay. Thank you. I put a question that clause 26 be amended as proposed by the minister. Honorable Magesi, those in favor stand the contrary nay. The ayes have it.
Clause 26 as amended.
I put a question that clause 26 as amended stands part of the bill. Those in favor stand the contrary nay. The ayes have it.
Clause 27.
Clause 27, yes. 27.
Procedure.
Right, Honourable Chair.
27.
Right, Honourable Chair. Clause 27 is amended. A, by substituting for subclause 1 the following. A person shall not practice valuation unless the person has a certificate of practice issued under Section 24, a license of practice for valuation firms issued under Section 25, or a temporary certificate of practice issued under Section 26. B, in subclause 2, by inserting the words other than the chief government valuer or a valuer in the office of the chief government valuer immediately after the word person. C, in subclause 4, by substituting for the words 500 currency points, the words 5,000 currency points. Justification. 1. Subclause 1 is amended to include a temporary certificate of practice issued under clause 26, since the holder of a temporary certificate of practice is eligible to practice valuation in Uganda. 2. The amendment to subclause 2 is intended to exempt the application of the provision to the chief government valuer or a valuer in the office of the chief government valuer, since they cannot undertake contractual valuation. 3. To ensure compliance of enhancing the penalty for the offense of practicing without a certificate of practice, temporary certificate of practice, or a license of practice.
Doug?
Madam Chair, I am sorry, but I think the committee is engaging in semantics. Clause 27.1. The committee has simply redrafted it. It remains meaning the same. I would propose that we maintain it as it is in its original position.
I put a question that clause 27 stands part of the bill. Those in favor sign the contrary nay. The ayes have it.
Clause 28.
I put a question that clause 28 stands part of the bill. Those in favor sign the contrary nay. The ayes have it.
Clause 29.
I put a question that clause 29 stands part of the bill. Those in favor sign the contrary nay. The ayes have it.
Clause 30.
Clause 30.
Right Honourable Chair, Clause 30 is amended in subclause 2 by substituting for paragraph D the following. D, an advocate recommended by Uganda Law Society. Justification, to enhance compliance with laws, regulations, and principles of fairness, equity, and a fair trial by including an advocate among the members of the disciplinary committee.
Why are you limiting it to a lawyer?
Right Honourable Speaker. Right Honourable Speaker. The clause as it is leaves leeway basing on the circumstances of each case. It can either be an advocate or any other person. So this D is
any other
properly
person with a
constituted.
good repute.
Yes, this D as it is properly constructed.
Okay. So we maintain?
Right Honourable, I propose that we maintain D as it is.
Okay.
Chair, I also want to a little bit differ from what the chair and the committee had proposed, especially on making sure it's a lawyer. In the profession of construction, we have people who might not be lawyers, but well versed with construction law, who are arbiters and all that. So I think D, as it is constructed, as long as he's a member of the professional body, there may be other credit score points that can add to the reputation of this person, qualifying him to be a member of this disciplinary committee. It doesn't have to be a lawyer.
Yes.
Thank you.
Yes, Honourable Minister.
Thank you, Honourable Chair. Honourable Chair, we are talking about composition of the disciplinary committee of council. The committee has failed to move a justification of why restrict this membership to a lawyer. I think we should leave it as it was drafted in the bill.
I put a question at clause 30 stands part of the bill. Those in favour sound the contrary. Eh? Yes, have it. Yes.
Right Honourable Chair, I am a member of the committee. We spent a lot of time doing a very good job. We gave all our defenses to the chair. The chair is just standing up to say, I concede, we concede, we concede. He's not even attempting to defend anything. As a member of the committee, I am feeling bad that my chair is only standing up to say, we concede.
As a member of the committee, you can stand up and say, we don't agree with that.
I patiently, yes, that's why I have been
patient. You put your argument, if it is substantial enough, and it carries weight, then we can adopt what you're saying. It's open for everybody.
Oh no, Chair, that is why I got concerned.
Okay.
And I started saying maybe I need to start defending the committee because the chair has given up.
31, clause 31.
Clause 31.
Right Honourable Chair, clause 31 is amended A, by inserting immediately after subclause 2 the following. A party to proceedings before the Value Reconciliation Committee who is aggrieved by the advice of the Valuation Reconciliation Committee who is aggrieved.
Honourable Mujiche, first come back. I have just checked the minutes. Honourable Mujiche did not attend the meeting.
Right Honourable Chair, I did not want to get into that, but at least the records are there, they speak for themselves. He did not even sign the report. So Honourable Chair,
Go ahead.
Yes, Honorable Chair, clause 31 is amended, A, by inserting immediately after subclause 2 the following. A party to proceedings before the Valuation Reconciliation Committee who is aggrieved by the advice of the Valuation Reconciliation Committee in subsection 2 may, within 30 days after being notified of the advice of the Valuation Reconciliation Committee, on which such further time as the High Court may allow, appeal to the High Court. B, by inserting immediately after subclause 4 the following. For purposes of subsection 1, the minister shall, in consultation with the council, by statutory instrument, prescribe the valuation of property with significant differences referred to in subsection 1. Right Honorable Chair, justification to provide for an option of appealing the advice of the Value Reconciliation Committee. 2, to empower the minister to define what amounts to significant differences.
Doug?
Madam Chair, there is proposed another insertion. I want the Committee of the whole House to understand that there are two valuations. One is statutory and the other is not. And we proposed an insertion of clause 4 for appeals to address statutory insertions. So we want to propose that this Value Reconciliation Committee shall not apply to statutory valuations.
Yes.
We wanted to be clear on that.
Thank you. We are okay with the insertion, but what about the amendment of the committee? You see, that committee is already for reconciliation. But when you look at what the committee says, a party to the proceedings before the Value Reconciliation Committee who is aggrieved by the advice of the Value Reconciliation Committee in subsection 2 may within 30 days after being notified of the advice of the Value Reconciliation Committee or within such further time as the High Court may allow, appeal to High Court. This is already a reconciliation committee. Why are you advising now to go to High Court? 31. But when, yes. Well, first, when you look at 31 to before you bring in the addition, the Value Reconciliation Committee appointed under Section 1 shall, within respect to the valuation, review the report of each of the valuer in accordance with the national valuation standards and shall provide advice on how the value of the property should be determined with the reason for the advice. Yes?
Right Honorable Chair, I look at the spirit of the bill. You've got an evaluation, you're not satisfied, there is a committee for reconciliation, you're putting your case there, the committee is constituted by council. Really, why are we now watering down the role of this reconciliation committee? I beg that the amendment be dropped. But the one of Attorney General.
Keep the insertion.
Yeah, I beg that we allow the one of the Attorney General, which is to the effect that this number 4 does not apply to statutory evaluation. So I think the Attorney General is correct.
Thank you. I put a question that clause 31 be amended as proposed by Doug.
Chair.
Those in favor say on the contrary, nay.
Maybe just before you could pass that.
Yes.
just on the same spirit that the Honourable Minister is raising it, and in regard to the proposal by Doug, I'm looking at it in this spirit of why should the valuation, the statutory valuation, be exempted from the Reconciliation Committee? I'm looking at it in this angle of, yes, government might want to use part of the property maybe for construction of a road, and I'm not content with the values that the government valuer has given me. Or maybe my private valuer has given me this value and government valuer is giving me this value. Why should it be that we exempt the valuation of the statutory valuation from going to the Reconciliation Committee? Shouldn't the House debate it more and understand? Because that way we shall be giving the office much more powers. Thank you.
How would you ease the avenues for government to acquire land? For instance, if you want to put a road and then somebody is saying don't, it's a polite way of compulsory acquisition.
Chair, maybe what if we said somehow indicated that the decision of the Reconciliation Committee is final. We avoid the part of where the committee was suggesting we go to High Court.
It is based on standards. There are already standards that are set. The national valuation standards are already set.
And they are talking of advice, not a decision.
Yes. Those in favor say and the contrary nay. The ayes have it.
Clause 32.
31.
Clause 31 as amended.
I put a question that clause 31 as amended stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Clause 32.
Chair.
Right Honourable Chair, for clause 32, there is substituted the following: valuation for tangible assets and intangible assets. For the purposes of this Act, valuation shall be undertaken to determine the value of A, tangible assets, intangible assets, and any other assets as may be specified by the National Valuation Standards. Right Honourable Chair, justification. Tangible assets and intangible assets are already broadly defined under Clause 1 of the Bill, making the current provision restrictive and contradictory. 2, to address the evolving nature of assets that can be valued based on economic cycles.
Honourable Chair, what amendment are you making? This is basically to show you what a tangible asset and what an intangible asset is.
Under interpretation clause.
What is the amendment meant to create? Yes?
Chair, this time round I'm with the chair of the committee. The chair of the committee says once you define tangible and intangible and you come to this clause and try to provide examples, then you are being restrictive. You are being restrictive. The proposal by the committee...
The statement is saying tangible assets including. It is not restricted. Including, among others.
Chair, again, in legislative drafting, this in itself is self-limiting. I don't know why they would even go ahead to do this. Including, but not limited to what? This in itself is a problem. So, Honorable Mwijuchi and my OB, Tony, the proposal, Chair, I want to invite the Minister.
Could we have this in the regulations to spell out what a tangible asset and intangible asset would mean?
Yes, because it
is already defined.
Yes, they are defined.
Madam Chair, I would have no problem with the way it's drafted because it has already been an issue that the chief government valuer, for instance, should have capacity to carry out valuation for the intangible assets. So I propose that we keep it the way it is, and then we put C. So we have A the way it is, B, then C becomes any other assets as may be specified in the regulations, and then to recover everything. And I don't agree with the committee that is the national valuation standards which will define those assets. It's the regulations. Then that will accommodate the interest of all of us.
Yes, Honorable Richard.
Madam Chair, I want to agree with the proposal by the committee this time, because in clause 1,
Okay, we concede.
we have defined the tangible asset to mean an asset with physical manifestation, and that include land, plant, machinery, fixtures, tools, and equipment, or any other asset of a physical nature. So by limiting us in the way 32 is drafted, we are being restrictive and ignoring the definition we have provided in clause 1. So I want to agree, Madam Chair, that we go with the proposal by the committee so that we don't restrict the tangible asset because we have already defined them in clause 1.
Are there any assets outside the tangible and intangible? First check, maybe that's the one you signed already. I concede.
Right Honorable Chair, we agree with the committee, but
Don't feel bad.
we wish to request the chair, you agree that any other assets as shall be specified in the regulations instead of these national valuation standards. Let's leave this to the minister to develop in the detailed regulations.
Chair.
Thank you.
Madam Chair. Madam Chairperson, Madam
Honorable.
Chairperson.
I think the committee is right on the national valuation standards, because you cannot just say that as defined by the regulations. You check what the valuation standards are. It's not defined per se. Yes, youth.
Chair, I wish to agree with the proposal by the minister. You see, the valuation standards, the standards are developed after there is need for a particular property, which can be either intangible or tangible, to be valued. So it is the regulations, if so provided, that can cause for standards to be put in place. So it would not be good for us to say that the standards are the ones which prescribe or describe what an asset should be. So I would propose we go with the proposal of the minister that regulations are the ones that cause for standards to be developed. Thank you.
Okay. On the regulations, we take the regulations. I put a question that clause 32 be amended as proposed by the minister. Those in favor say on the contrary, nay. The ayes have it.
Clause 32 as amended.
I put a question that clause 32 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 33.
I put a question that clause 33 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 34.
34.
Right Honorable Chair, Clause 34 is amended in subclause 1A by substituting for paragraph A the following. A, the name of the person for whom the valuation is undertaken, the name of the practicing valuer who undertakes the valuation, the scope of work performed, the purpose of the valuation, the description of the asset valued, and the valuation date, which shall be the effective date of the valuation. B, in paragraph B, by inserting immediately after the word valuation, the words principles and valuation. Justification. 1. Subclause 1A is amended to require a valuation report to indicate the name of the person for whom the valuation is undertaken and to remove any reference to a certified valuer, since a certified valuer is not entitled to practice valuation. 2, to include valuation principles applied to the valuation in the valuation report.
Yes, Doug.
Right Honourable Speaker, if I've understood my colleague, the chairman of the committee, his proposal is, or the committee proposes, to delete the term certified valuer. And it would also be proposing to retain the term practicing valuer. Our proposal as government, Right Honourable Speaker, that the term certified valuer and practicing valuer be maintained, since all enrolled valuers are referred to as certified valuers of Uganda under clause 22, subclause 4. Justification being that all valuers must follow the national valuation standards referred to in clause 8D and E of the bill. As I conclude, Right Honourable, I want to remind you that you did not remind the Mijuche to concede.
Honourable Mijuche.
Honourable Chair,
Honourable
first of all,
Mijuche, are you okay with that?
I wanted to clear the record that I did not participate. I participated fully, but like you remember, you sent me to Italy. So the time they were signing was not around. But when I came, I agreed with the report. So
Now
it's not true that I did not
Stop
participate.
blackmailing the presiding officer.
So
the issue.
I concede.
You concede with what Daga is saying. Good. I put a question on the same. Yes. By the way, we need to move faster. We still have 2 bills. And we are here and we have local government. Yes, don't repeat the same thing. If you, that's what he... I put a question that clause 34 be amended as proposed by Doug. Those in favor say on the contrary, nay. The ayes have it.
Clause 34 as amended.
I put a question that clause 34 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it. There were 2 amendments.
Yes, for the record.
The amendment is by Doug.
So we are dropping the one of the committee.
35.
Clause 35.
Right Honourable Chair, Clause 35 is amended in Clause 4 by substituting for the words, for the avoidance of doubt, the words for purposes of subsection 2. Justification: to align subclause 1, 2, and 4, since the period of validity referred to in subclause 4 only applies to subclause 2.
Yes, Isaac.
Chair, I think the same issue applies here in clause 34, whereby the term certified value and practicing value are all to be maintained. And here they are proposing to delete it again. So since we adapted it in clause 34, I think we should also maintain both terms in this.
No.
In clause 36.
We're in clause 35.
Sorry, 35.
35, we're in 35. Minister, are you okay with what they are proposing?
We agree, Right Honorable Chair.
He says for purposes of subsection 2, and he wants to remove for avoidance of doubt, a period of validity of the valuation shall start from the day of the last inspection. Which? Honorable Minister, you're restricting yourself on 2, but even 3 is speaking to the same valuation.
Madam Chair, I suggest we maintain the original formulation.
Thank you.
Because it's more clear.
Thank
you are
you.
saying, for avoidance of doubt, the period of validity of evaluation shall start on the date of the last inspection of the property under valuation. I think this is more clear
Thank
than
you.
what the committee is suggesting. Instead of
I
limiting
put a
it.
question at clause 35 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 36.
Right Honorable Chair, Clause 36 is amended by deleting the words certified valuer wherever the words appear in the clause. Justification: to avoid ambiguity, since the valuers in the office of the chief government valuer are also practicing valuers under the bill.
I think this one has a consequential amendment from what Honorable Dags talked about in 34, that the certified valuers and practicing valuers should be maintained since they are the enrolled valuers. It's a consequential. So we have to leave it. Not so, Minister? Doug?
Right Honorable, it is a consequential amendment.
I put a question that clause 36 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 37.
I put a question that clause 37 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 38.
Clause 38.
Right Honorable Chair, Clause 38 is amended A in subclause 1 by deleting the words a certified valuer.
That it still
It
has
is still consequential, yeah.
I put a question that clause 38 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 39.
39.
Right Honorable Chair, Clause 39 is amended in subclause 2 by adding the following words at the end of the provision: and is liable on conviction to a fine not exceeding 5,000 currency points or imprisonment not exceeding 2 years or both, immediately after the word offense. Justification: to provide a penalty for the offense.
Thank you, Minister.
Honorable Chair, it is okay to provide a penalty, but 5,000 currency points, honorable colleagues, times 20,000, that sounds like 100 million. Is it possible, Right Honorable Chair, to scale it down, to be a little more realistic?
How much are you proposing?
I would propose, no, not a halfway. I'm looking at 10 million, if that can be put into currency points. 500 currency points. Yeah.
500 currency points as a new insertion. Doug?
Right Honorable.
The gravity is less than the building one.
Right Honorable, it is difficult to assess at this level because we don't know the gravity. But yeah, we do not have a basis. But maybe 1,000 currency points would suffice. But you see the problem with that, the Right Honorable Speaker, the problem with us speculating that either 1,000 or 500 or 5,000, that the effect of this problem may be so huge, it might be in billions, and yet the fine is only going to be either 5 million or 10 million.
From my side,
You
Madam
know,
Chair.
what the chairperson is raising is very valid. The gravity is high. If you've been removed from practicing because of malpractice, then why should you continue practicing?
Madam Chair.
Madam Chair,
Madam Chair, allow me to
the
start with the
wording
chair.
would save us if we say not exceeding 5,000, so that whoever sits in judgment takes into consideration the gravity and makes the necessary adjustments.
Yes. And that's what the committee said, not exceeding 5,000 currency points. That is, so we go by the committee's.
Madam Chair, there is a law which relates the currency points, the period of confinement. I don't know whether the committee tried to look at that comparison. Yes.
One currency point to 2 months in jail.
Yes, but it was very specific. It was very specific. But for purposes, if you want to create these severe punishments, then there's absolutely nothing for us to provide it that way. But then the wording would change, so without prejudice to the other legislation, if that is what we prefer to make it such deterrent.
So what are you proposing?
No, I actually have no problem with the position of the committee. Yeah.
Okay, I put a question that clause 39 be amended as proposed by the committee. Those in favor say and contrary nay. The ayes have it.
Clause 39 as amended.
I put a question that clause 39 as amended stands part of the committee. Those in favor say and contrary nay. The ayes have it.
Clause 40.
I put a question that clause 40 stands part of the bill. Those in favor say and contrary nay. The ayes have it.
Clause 41.
I put a question that clause 41 stands part of the bill. Those in favor say and contrary nay. The ayes have it.
Clause 42.
I put a question that clause 42 stands part of the bill. Those in favor say and contrary nay. The ayes have it.
Clause 43.
I put a question that clause 43 stands part of the bill. Those in favor say and contrary nay. The ayes have it.
Clause 44.
Chair.
Right Honorable Chair, Clause 44 is amended in subclause 2A by substituting for the words Land Valuation Management Information System, the words National Valuation Information System. Justification to achieve consistency with Clause 3, which creates a national valuation information system.
Yes, Alan.
Thank you, Chair, for the opportunity. Honorable members, the Acting Right Honorable Rob. Right Honorable Chair, normally regulations of various acts are tabled or laid before Parliament, notifying the House of the honorable members. Right Honorable Madam Chair, for this to be anchored in the bill, I therefore propose we amend clause 44 by inserting sub-clause 4 to read as follows. Regulations made under this section shall be tabled or laid before Parliament by the minister responsible. Justification. Justification for notification purposes to the House. I beg to submit.
The timeline within 3 months from adoption of this report. No, I'm giving him. We need a timeline. You cannot just make a law and we sleep over it and we don't have the regulations.
Madam Chair, I didn't give the timeline because to give the minister room at any time when should come in.
Let's not give them an open. Yes.
You've just proposed 3 months. It's up to them to tell us that no, we can do it in 6 months, other than leaving it open.
Yes.
Madam Chair, it has been a challenge that we pass here laws and it takes forever for the executive to actually have the regulations in place. And that makes implementation even problematic. So, Madam Chair, I want to propose that we give a 6 months time limit that the minister shall lay regulations within 6 months.
6 months of what? Formulation?
No, from the date of assent. From the date of assent. Because the president is the one who assents to these bills. So once he has assented, then the minister should within 6 months have regulations worked on and then laid before this House. Thank you.
Madam Chair, the way the law is couched is saying the minister may make regulations. So I thought you were comparing the minister to lay the regulations once they have been gazetted. Once the minister makes regulations and they are gazetted, that's when you compare the minister that within 3 months they be laid. No.
We are saying, why are we saying may? We are making an adjustment that the minister shall. Let's not have people who don't want to work.
No.
Honorable Minister, let's first adopt shall.
No. Because the minister who is implementing this law...
This is the House that is making this law. We need to know what is happening. Honorable Minister, let's have respect for your House.
I just want to emphasize because, Honorable Minister, we just referred in clause 32 where we were arguing about the tangible and intangible assets, and we left it to the regulations to define and give details. Now imagine we leave you with the forever to make regulations. How are we going to implement this? So it shall, the minister shall. We are removing may because we have already provided for regulations in the bill.
You see, on the issue of regulations, when you look at the pieces of legislation that we make, these regulations usually are made in different circumstances and situations. You don't condition them on specific times. Honorable Yumus was trying to raise the issue, but I don't know why he ran away from the microphone.
Honorable, the shall should be tabled in the house. For tabling it in the house, let's make it mandatory that it should be tabled in the house.
Right, Honourable Speaker, by the way, our rules of procedure say so. Yes. You don't have to even to label it in these regulations. Our rules of procedure require that they are tabled. And by the way, they are tabled for information purposes, but not even debate.
Yeah.
Yes.
So what's wrong with that?
Madam Chair, from the side of independence, really, yes, Madam Chair, we are giving that shall because we have seen the problems before. And this is the House which is responsible for legislation. And I want to agree with you, Madam Chair, that we have decided to compel ministers as a shall to be bringing here what? Regulation. And should be within 6 months.
To table.
And should be tabled within 6 months from the date of assent.
You see,
Honourable members,
let's educate colleagues on the word shall. By the way, shall does not mean mandatory. It doesn't mean mandatory. Neither does may mean discretion. And the Supreme Court has guided on this issue several times. Because I know colleagues want to get excited that we use the word shall. The shall.
Honourable members, can we have the amendment? Are we in agreement with an insertion that the regulation shall be laid on table?
Thank you, Right Honourable Chair. The regulations made under this section shall be tabled before Parliament within 6 months of gazettement.
Thank you.
Thank you.
I put a question that clause 44 be amended as proposed by the minister. Those in favour stand the contrary nay. The ayes have it.
Clause 44 as amended.
I put a question that clause 44 be amended as proposed by the LOP and amended by the minister. Those in favour say the contrary nay. The ayes have it.
Clause 44 as amended.
I put a question that clause 44 as amended stands part of the bill. Those in favour say the contrary nay. The ayes have it.
Clause 45.
Clause 45.
Right Honourable Chair, Clause 45, substitute for Clause 45 the following. 45, Amendment of Cap 303. The Surveyors Registration Act is amended in Section 1, subsection 1 by repealing the term valuation surveyors appearing in the definition of surveyor. Justification for accurate reference.
Thank you, Right Honourable Chair. I agree with the Chair, but when you look at the way it is proposed, by repealing the term valuation surveyors in section 1.1, you don't have again to put which is appearing in the definition. That is a definition interpretation clause. So if we can leave out the final clause, section which is saying appearing in the definition of surveyor, that's not necessary. The rest is okay.
I put a question that clause 45 be amended as proposed by the committee and further amended by the minister. Those in favour say the contrary nay. The ayes have it.
Clause 45 as amended.
I put a question that clause 45 as amended stands part of the bill. Those in favour say on the contrary nay. The ayes have it.
Schedule 1.
I put a question that the first schedule stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Schedule 2.
I put a question that second schedule stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Title.
I put a question that the title stands part of the bill. Those in favor say and the contrary nay. The ayes have it.
Motion for resumption of the House.
Honorable Minister.
Right Honorable Chair, I beg to move that
There
the
is
House
a
do resume
committal.
and the Committee of the Whole House reports thereto.
Section what?
Chair, when we amended the Section 8, there was a consequential amendment that we missed. I think 8B.
Let's first.
Yes, at 8B, we said the council shall register certified valuers and practicing valuers and added valuation firms.
Yeah, that is a consequential.
Yes, and
it will be included in the when they are cleaning.
So at D, that's what I wanted valuation firms
you
to
don't
be.
need to do a recommittal. At the cleaning level, they will do it.
Oh, okay.
Yes, it's a
Also,
consequential.
Chair, maybe something, because this law, at a certain point at interpretation, sometimes they would require to consult our Hansard. We went on insisting that we insist and maintain certified valuers, and went on saying which should be maintained without justifying why. I felt maybe to provide spirit to that principle, Right Honorable, because the committee already grappled with interpretation. Certified valuer, practicing valuer, they grappled with it, and in future it could be a problem. However, Right Honorable Speaker, what I could say to that.
So you wanted it to be defined under interpretation?
No, not defined, but speaking to it, justification to it, just in future, in case anyone ever consults our Hansard to understand why.
You want to explain it?
Yes, I want to explain it, why. Right Honorable Speaker, for example.
Okay, can we first, for good flow of the Hansard, can we first resume the House?
Okay.
Yes, then you'll explain that even when we are finished, when you're thanking us.
Motion for resumption of the House.
Honorable Minister.
Thank you, Right Honorable Chair. Right Honorable Chair, I beg to move that the House do resume and the Committee of the Whole House reports thereto.
I put a question that the House resumes and the Committee of the Whole House reports thereto. Those in favor say and the contrary nay. The ayes have it. You.
Report of the Committee of the Whole House.
Honorable Minister.
Right Honorable Speaker, I beg to report that the Committee of the Whole House has considered the bill entitled the Valuation Bill 2024 and passed it with amendments.
Motion for adoption of the report of the Committee of the Whole House.
Honorable Minister.
Madam Speaker, I beg to move the motion that the report the Committee of the Whole House be adopted. I beg to move.
I put a question that the report of the Committee of the Whole House be adopted by this House. Those in favor say and the contrary nay. The ayes have it.
Bill's third reading, the Valuation Bill 2024.
Honorable Minister.
Thank you, Right Honorable Speaker. I beg to move that the bill entitled Valuation Bill 2024 be read the third time and do pass. I beg to move.
I put a question that Evaluation Bill 2024 be read the third time and do pass. Those in favor say the contrary nay. Let's have it.
A bill for an act titled the Valuation Act 2025.
Title settled and the bill passed. Youth.
Thank you. Right Honorable Speaker, I beg to thank you and thank the House for doing a very good job. It's been a lengthy report and bill, marathonly handled, but it has been well done. I thank you, Right Honorable Speaker, and the entire House.
Thank you. The youth has something. Honorable Dago, we still have another bill. The mortgage financing. We need you.
Right Honorable Speaker, again on behalf of the professions in the world of the sphere of built environment, I wish to extend our sincere gratitude to you and gratitude to the entire House, the members and the Minister for the resilience you have showed in ensuring that this bill is discussed and passed. And I also want to extend extraordinary gratitude to the Speaker for exuding extraordinary knowledge, because she made unique and I can say unique contributions, again showing how she has evolved in the professional world. Right Honorable Speaker, I also wish to again hit...
Youth, just a minute. Our friends from Mulga, we have a suggestion that we discuss this issue of local governments when the House is full on Tuesday, so that we have everybody participate in the debate, because these people represent people who are at the lower level. So we want to have a thorough discussion on your report. And I'm happy the Minister has a response to all the issues that you raised. So kindly bear with us. We'll discuss your report on Tuesday. Thank you. Right. Inshallah. Okay.
Honorable Speaker, thank you once again. Honorable Speaker, what I was trying to explain earlier at the level of recommittal on the issue of certified valuers and practicing valuers. Honorable Speaker, I just wanted to draw a small distinction. Honorable Speaker, all valuers under the office of the Chief Government Valuer are supposed to be certified, but they are not practicing valuers because they are not allowed to go into contractual obligations of valuation. So, but meanwhile, they do government work and produce valuation reports. So that is why we went on maintaining the word certified valuers. Even when they are not practicing, they are also allowed to produce valuation reports. Thank you, Honorable Speaker.
Thank you. Next item.
Item 7 on the order paper, Bill second reading, the Mortgage Refinance Institutions Bill 2025.
Honorable members, the Mortgage Refinance Institutions Bill 2025 was read for the first time on 12th March 2025 and referred to the Sectoral Committee of Finance, Planning and Economic Development, and pursuant to Rule 136(1) of the Rules of Procedure, I want to invite the Minister of Finance, Planning and Economic Development to move a motion for the second reading. Honorable Minister. Yes.
Thank you very much, Madam Speaker, for your leadership and guidance. I don't intend in any way to interrupt the proceedings of the House, Madam Speaker, but only to appeal, me as your representative, only to bring to your attention that the arts teachers have sounded and sent a clear warning and signal that they're not going to report back to school next week. Madam Speaker, and the entire House, I would rather that we prioritize this item because we don't want no interruption in our school system. The Minister for Finance is here. Mr. Minister.
Honorable Atkins, can we kindly first move? Then you'll bring those issues.
It's going to be today, Madam Speaker, because your teachers want to strike next week, and we want no interruption in our school system. The Minister is here. The issue is they want to strike, Mr. Minister. And we don't want no school interruption next week.
Honorable Minister, can you first move a motion that will come after our bill?
They want to strike.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I beg to move a motion that the bill entitled the Mortgage Refinancing Institutions Bill 2025 be read for the second time.
Seconded by Omara, by Sailo, by Ivanda, by To, Malanyo, Afande, Honorable Badomusi Ogwang, Dag, the chairperson of finance, Olanya, Chemongesi, Isaac, Basil, Isaac again, my son, and then Goli. Even Sarah, she's here pretending, and Achora and Emmanuel. Speak to your motion.
Madam Speaker, the Mortgage Refinancing Bill seeks to empower Bank of Uganda to license and oversee mortgage refinance institutions, including those offering Islamic financing, to provide for stable long-term capital for mortgage lending. The key objectives include enabling primary lenders to offer long-term tenures and lower interest rates, and ultimately making home ownership more accessible, particularly for middle and low-income Ugandans. Madam Chair, we presented this bill to the committee, and I am reliably aware that the committee has made a good report which will inform the debate of this bill. And without wasting time of Parliament, I want to end here. Much more justification will come in the committee report. I thank you.
Thank you, Honourable Minister. Pursuant to Rule 136(2) of the Rules of Procedure, I want to invite the chairperson of the Committee of Finance, Planning and Economic Development to present a report. And we'll have this report on the Hansard, but you can give us a summary.
Thank you, Madam Speaker. As stated by my minister, this bill was brought to Parliament on the 12th of March 2025, and the committee was assigned the responsibility, and I hereby report. Allow me to lay the minutes and attendance, the relevant documents that the committee handled, I hereby lay. Madam Speaker and honorable colleagues, the objects of the bill have been ably re-echoed by the minister. Therefore, allow me to just highlight a few justifications for the bill. The findings of the National Population and Housing Census 2024 revealed that 60% of Ugandans still live in informal settlements or inadequate housing conditions. The gap is driven by rapid urbanization, population growth, and economic disparities. Closing this housing gap, therefore, is a big investment opportunity under the tenfold growth strategy. Annually, over 1 million Ugandans are born, putting pressure on the country's housing sector. With a population growth of 2.9%, coupled with urbanization growth rate of 5.4%. The country must therefore build 300,000 housing units annually to bridge the gap of 2.4 million housing deficit, which is projected to reach 3 million units by 2030 if not addressed. It is against that background that this bill, honorable colleagues and members, is very important. The methodology that was handled by the committee included review and made reference to the following documents: the Constitution of the Republic of Uganda, the Mortgage Act Cap 239, the Uganda National Housing Policy 2016, the NDP4, the Central Bank of Kenya Act Cap 491, the Mortgage Refinance Companies Regulations 2019, Kenya, Central Bank of Nigeria Regulatory and Supervisory Framework for the operations of Mortgage Refinance Company, the Banking and Financial Institutions Act, Cap 342, Tanzania, the Banking and Financial Institutions Mortgage Refinance Companies Regulations 2022, Tanzania, the National Population and Housing Census 2024 final report. We had meetings with the following: the Minister of Finance, Planning and Economic Development, the Attorney General, Bank of Uganda, Uganda Bankers Association, the Private Sector Foundation Uganda, Uganda National Housing and Construction Company Limited, the National Social Security Fund, the National Planning Authority. Altus advocates submitted a memorandum. And allow me, Madam Chair, Madam Speaker and honorable colleagues, to go straight to the National Development Plan 4. National Development Plan 4 highlights the housing deficit in the country, as earlier said. Allow me to skip that since it came into the introductory remarks. Madam Speaker, allow me to go straight to the findings and observations and recommendations of the committee. The Attorney General made a waiver of Cabinet approval. The committee was informed by the Minister of Finance that the Attorney General granted a waiver under Section QB, Paragraph 2C of the Uganda Public Service Standing Orders 2021 for the requirement of the Cabinet approval of principles of drafting of the Mortgage Refinance Institutions Bill 2025. This was confirmed by the Attorney General when appeared before the committee. The principles of the bill were therefore not referred to the Cabinet for approval. The Minister of Finance informed the committee that given the urgency of the bill at the time, the Attorney General granted the waiver for Cabinet approval of the principle of drafting of the bill. The Attorney General, during the meeting with the committee, presented the letter dated 18th March 2024, addressed to the Deputy Head of Public Service, Deputy Secretary to the Cabinet. And the letter indicated that the approval of the drafting of the bills without prior reference to the Cabinet for approval of the principles of drafting of the bill. The letter also indicated the special circumstances as urgent need to provide for licensing of the mortgage refinance institutions to carry out mortgage refinance business for purposes of refinancing or pre-financing of portfolios of mortgages to enable primary mortgage lenders access long-term funding and be able to offer mortgages at low interest rates. The committee further observed that the Minister of Finance and Attorney General did not provide elaborate explanation of the urgency that warranted drafting of the legislation without prior approval of the Cabinet. The committee recommends, therefore, the Minister of Finance and other ministries should plan legislation ahead of the time to ensure that duly approved procedure of the bill is tabled in Parliament is followed. The absence of regulatory impact assessment. The committee noted that a regulatory impact assessment was not conducted for the mortgage refinancing bill. The committee requested the Ministry of Finance provide reasons as to why the RIA was not carried out. In response to the inquiry, the Ministry cited that the urgency of the bill then caused the circumstances to be so. The committee noted that the letter granting the waiver of the Cabinet approval of the principles for the drafting of the bill was dated 18th March and received by the Bank of Uganda on the 20th March 2024. The bill was read for the first time in floor of Parliament on the 12th of March 2025. The committee observes that the need to provide for an RIA enables the government proposed legislation guided by evidence, cost-benefit analysis, and facilitates stakeholder consultation. The committee recommends that the ministry should conduct an RIA for mortgage refinance institutions for further guidance. Provision for Islamic banking. Clause 2 provides that Islamic mortgage refinance business means mortgage refinance business conducted in accordance with the Sharia principles through an Islamic window. Clause 6 of the bill provides for licensing of an Islamic mortgage refinance business. An Islamic window is defined under the bill to mean part of a mortgage refinance institution which conducts Islamic mortgage refinance business / institution. The committee observed that the bill does not include a fully fledged Islamic mortgage refinance business / institutions. This was affirmed by the Uganda Bankers Association. The committee inquired from the ministry about the non-inclusion of fully fledged Islamic mortgage refinance institutions, and Ministry of Finance informed the committee that the bill recognizes the fact that some primary mortgage lenders may either be Islamic financial institutions or providers of Sharia-compliant mortgages as part of their portfolios. The committee was concerned that the maintenance of the provision on Islamic finance as it is in the bill would undermine the full operationalization of a fully fledged Islamic mortgage refinancing business or institution. The committee recommends, therefore, that a provision of a fully fledged Islamic mortgage refinancing institution / business should be included in the bill. And I want to appreciate some of our colleagues on the committee that are within the Islamic discipline, particularly Honorable Kalim Masaba and the rest members who gave enough information. Licensing of mortgage refinance institutions, suspension of license. The committee observed that Clause 10, subsection 3 of the bill provides for revocation or suspension of a license. The grounds for revocation are clearly spelled out under Clause 11. However, no grounds of suspension were indicated. In the interaction with the committee, the sponsor of the bill informed the committee that the bill did not intend to provide for suspension of licenses of the mortgage refinance institutions, and the use of the word suspended was in error. The Ministry of Finance explained to the committee that given the sensitivity of the financial sector, they only intended to revoke licenses as opposed to suspension. Recommendation. The committee recommends that the provision be amended to only provide for revocation of license. Clause 11, subsection 2F of the bill provides that the central bank may revoke the license of the mortgage refinance business within 12 months from the date of issue of a license if satisfied that the licensee obtained the license through unlawful means. The committee observed that the use of the word unlawful means is ambiguous. The clause should specifically provide for fraud and misrepresentation as some of the actions which it is intended to present. Recommendation. The committee recommends that the provision should specify that the words unlawful means, I beg your pardon. The committee recommends that the provision should specify that the words unlawful means include fraud and misrepresentation. Minimum capital. Clause 14 of the bill provides for minimum capital for the mortgage refinance institutions. Minimum paid-up capital required for the establishment of mortgage refinance institution shall be 1,750,000 currency points, equivalent to 35 billion Uganda shillings, invested initially in such liquid assets as the central bank may approve. The provision states that the minimum capital fund requirements for the mortgage refinance institutions unimpaired by losses shall at all times not be less than the minimum paid-up capital prescribed in subsection 1. The provisions also allows the central bank by statutory instrument to revise the minimum paid-up capital. The committee observed that the minimum paid-up capital of 35 billion shares compares well with other countries within the region. The committee recommends that the provisions on minimum capital of 1,750,000 currency points be maintained as it is in the bill. A default on obligations to mortgage refinance institutions. Clause 20 of the bill provides that the collateral pledged by a primary mortgage lender to a mortgage refinance institution shall not be attached, assigned, or transferred for purposes of satisfying any debt or claim. The committee interacted with the National Social Security Fund, which also observed that the bill does not provide for recovery of loans and default on loans by primary mortgage lenders. The committee observes that there is no procedure outlined under this clause in the event of default by the primary mortgage lender. It cannot be expected that the primary mortgage lender will default on its obligation to the mortgage refinance institution. Recommendation. The committee recommends that a provision to remedy default by the primary mortgage lender be included in the bill. Limit on shareholding in the mortgage refinance institution. Clause 24 provides for 25% limit on shareholding in an MRI. Members, MRI is mortgage refinance institutions. This limit applies to a person, body corporate controlled by one person, group of related persons, or body corporate owned or controlled directly or indirectly by a group of related persons. However, this limit shall not apply to the government of Uganda, agency, or parastate of the government of Uganda. The Uganda Bankers Association informed the committee that there is need to allow reputable institutions or strategic investors to hold beyond the 25% limit under this provision for the first 5 to 7 years, subject to sunset clauses and central bank oversight. The National Planning Authority also informed the committee that government should not be exempted from the 25% limit in order to catalyze private financiers. NPA further stated that there is need to provide for regulatory approval in the event of acquisition of a significant stake by an individual or institution. The committee observes that the clause aims at preventing a single person or group from gaining undue influence or control from owning more than 25% stake, and this will promote a more diversified and stable financial system. 2, the provision does not provide for regulatory approval in the event of acquisition of a significant stake, for example, 10% or more, by an individual or institution. And the committee therefore recommends that the central bank should provide approval for an individual or institution to acquire more than 10% of the share capital of the MRI. Cost of mortgage. The Ministry of Finance informed the committee that the Mortgage Refinance Institutions Bill intends to address unfavorable mortgage terms, high default rate on repayment of mortgages by providing long-term funding to the primary mortgage lenders, in order for them to offer mortgages to the public at a more affordable interest rates, manageable payment installments, and long-term payment durations. The committee was informed by NPA that there could be a possibility of a primary mortgage lender accessing favorable financing from the MRIs and then channel it to expensive private capital or investment in government paper, and thereby leading to the limited growth in the mortgage sector. The committee observed that given that there is no direct relationship set out in the bill between the MRI and persons with mortgage portfolios under the primary mortgage lenders, there is no guarantee that the intention of the bill will be met. The committee further observed the forces of demand and supply will affect primary mortgage lenders, and this may further curtail the intentions of the bill. Recommendations. The committee recommends that the central bank, in consultation with the minister, should cap interest rates on the mortgages under the mortgage refinance arrangements. Affordable housing. The committee was informed by the Minister of Finance that the bill will address the housing deficit in the country by providing financing for primary mortgage lenders, which in the long term will have an effect of facilitating affordable housing in Uganda. The committee was informed by the ministry that according to the recent reports from the Ministry of Lands, Housing and Urban Development, the current housing deficit is 2.4 million housing units as at 2023, projected to reach 3 million units by 2030 if not addressed. The committee was informed by NPA that the bill would benefit from more detailed provisions on consumer protection, affordable housing targets, market incentives, and integration with broader housing frameworks. The committee observes that in the sustainable urbanization and housing programs in NDP4, government priorities, well-planned and productive urban centers with affordable housing. The specific initiatives include capitalizing Housing Finance Bank and National Housing and Construction Company by extending credit lines targeting mortgage funding to low-income earners. 2, fast-tracking establishment of a mortgage refinance facility. And 3, increasing access to non-bank housing financing, such as housing circles, savings schemes, and shelter microfinance facilities. And 4, developing and implementing slum upgrading programs in urban areas through PPPs. The committee therefore recommends that in order to attain affordable housing, the government of Uganda should expedite implementation of the measures under the Sustainable Urbanization and Housing Program under NDP4. In conclusion, Madam Speaker, the Mortgage Refinance Institutions Bill 2025 will help solve the problem of loan mismatch, where financial institutions use short-term deposits by customers to lend to mortgagors. I submit right.
Thank you, Honorable Chair. You've had a report, very comprehensive. Yes, we can now go to committee stage where we can be looking at a clause by clause. I put a question that the Mortgage Refinancing Institutions Bill 2025 be read the second time. Those in favor say on the contrary, nay. The ayes have it.
The Mortgage Refinance Institutions Bill 2025, Bills Committee stage. Clause 1.
I put a question that clause 1 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 2.
Clause 2.
Madam Chair, we propose that clause 2 be amended. A, by substituting for the definition of the word Islamic mortgage refinance business, the following. Islamic mortgage refinance business means mortgage refinance business conducted in accordance with Sharia principles, or B, through Islamic window. And B, by inserting immediately after the definition mortgage, the following. Mortgage portfolio means a collection or grouping of mortgages held by a primary mortgage lender, each representing a loan made to a borrower to purchase or refinance a property, and includes mortgages over land used for residential, commercial, industrial, or agricultural purposes. And C, in the definition of the word mortgage refinance business, in paragraph C, by inserting the words for the purposes of mortgage refinance business immediately after the words financial instruments. And D, by inserting immediately after the definition of mortgage refinance business the following. Pre-financing means the extension of credit by a mortgage refinance institution to a primary mortgage lender against qualifying collateral other than a mortgage portfolio to enable the primary mortgage lender to create mortgage portfolio. And E, by inserting immediately after the definition of primary mortgage lender the following. Refinancing means the extension of credit by a mortgager, the extension of credit by a mortgage refinance institution to a primary mortgage lender against a mortgage portfolio already created by the primary mortgage lender. Justification: 1, to provide for the operation of a fully fledged Islamic mortgage refinance business, and 2, to provide for a definition of the word mortgage portfolio as it is used in the bill severally but not defined, and 3, to specify that the bonds, notes, and other financial instruments are particularly for purposes of mortgage refinance business, and 4, the words refinancing or refinancing as used in the definition of mortgage refinance business are technical terms and thus should be defined. I submit.
Thank you. Honorable Minister.
Thank you, Madam Chair. Madam Chair, I agree with the committee chair on the definition of Islamic finance, mortgage portfolio, definition of mortgage refinancing business. I also agree that we define pre-financing and refinancing. However, I have a shorter version.
You have a what?
A shorter version of the definition of pre-financing, and I want to propose it as to read as follows. Pre-financing means the prior grant of funds by a mortgage refinance institution to a primary mortgage lender for purposes of on-lending, full stop. Then on refinancing, refinancing means a financial tool used to revise debt, consolidate debt, obtain lower interest rate, and access equity. Full stop. I submit, Madam Chair.
That is on pre-financing.
C and D to avoid a lot of wording.
Madam Chair, it is a matter of English, and indeed that's why my minister said that he's preferring a shorter version.
Yes.
However, I only have one area of disagreement, or maybe something to add. It shouldn't be on lending, but onward lending.
Onward lending. I put a question, onward lending. I put a question that clause 2 be amended as proposed by the committee and further amended by the minister. Those in favor say on the contrary, nay. The ayes have it.
Clause 2 as amended.
I put a question that clause 2 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 3.
Honorable member, Chair.
Madam Chair, clause 3 is about object of the act. Clause 3 is amended in paragraph B by deleting the words through an Islamic window. Justification: this is a consequential amendment since the definition of the word Islamic mortgage refinance business has been defined to include a fully fledged Islamic mortgage refinance business.
Thank you, Minister.
Madam Chair, this is the harmonized position with the committee. I therefore agree.
I put a question that clause 3 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 3 as amended.
I put a question that clause 3 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 4.
I put a question that clause 4 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 5.
I put a question that clause 5 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 6.
Clause 6.
Madam Chair, clause 6 is about Islamic mortgage refinance business. Clause 6 is amended in subclause 1 by deleting the words through an Islamic window. Justification: this is a consequential amendment since the definition of the word Islamic mortgage refinance business has been defined to include a fully fledged Islamic mortgage refinance business.
Minister. Consequential amendment. I put a question that clause 6 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 6 as amended.
I put a question that clause 6 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 7.
I put a question that clause 7 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 8.
I put a question that clause 8 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 9.
Clause 9. I put a question that clause 9 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 10.
Clause 10.
Madam Chair, clause 10 is about grant of license. Clause 10, subsection 3, is amended by deleting the words or suspended. Justification: the bill provides for grounds of revocation of license, but not the grounds for suspension of license. Therefore, the word suspended was placed under this provision in error and should thus be deleted.
Honorable Minister.
It's a harmonized position. I agree.
I put a question that clause 10 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 10 as
I
amended.
put a question that clause 10 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 11.
11.
Madam Chair, clause 11 is amended. A, in subclause 2C, by inserting immediately after the word proceedings the words in accordance with the Insolvency Act. And B, in subclause 2F, by inserting immediately after the words unlawful means the words including fraud or misrepresentation. And C, by inserting immediately after subclause 2I the following: J has conducted Islamic mortgage refinance business in contravention of the Sharia principles. Justification: to provide clarity that the insolvency proceedings are as set out in the Insolvency Act, Cap 108. And 2, to specify that the words unlawful means as used under the provisions includes fraud or misrepresentation. And 3, to provide for revocation of license where an MRI conducts Islamic mortgage refinance business in contravention of the Sharia principles.
Honorable Minister.
Madam Chair, from our harmonized position, the Chair has added C to provide for Islamic finance business. And since we have defined it already in the interpretation, the intention is good. I therefore agree with the Chair.
Thank you. I put a question that clause 11 be amended as proposed. Those in favor say the contrary nay. The ayes have it.
Clause 11 as amended.
I put a question that clause 11 as amended stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 12.
I put a question that clause 12 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 13.
I put a question that clause 13 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 14.
I put a question that clause 14 stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 15.
Chair.
Clause 15 is about limit on investments. Clause 15 is amended. A, in subclause 1B, by substituting for the word and the word or, and B, by inserting immediately after subclause 1B the following. C, investments which comply with Sharia principles as approved by the central bank. Justification: the intention of the provision is for the mortgage refinance institutions to invest in any of the investments, but not in all investment listed in the provision. B, to provide for investments which comply with the Sharia principles, which are not provided for under the provision.
Madam Chair, I'm very suspicious with the clause 15, 1A. Treasury
15 what?
1A. Treasury securities or equivalent instruments issued by the government of Uganda.
1A.
Yeah, the whole idea here is for these companies to trade in mortgages. But again, having them or giving them a leeway to trade in securities might congest our local market. And I suggest we delete that clause 1A. Thank you.
Yes, Chair.
I want to appreciate my colleague's observation. This is a matter that we also observed as a committee, but taking his proposal would be more of speculative than actual. So that's why we ignored it.
Yes.
Thank you, Chair, for the opportunity. Chair, I wanted clarification from Chair when you look at clause 15. When you look at the bill 1B, it has words and, there are two ands. As in the words and there are two.
The committee has already amended that.
Okay, and Chair, when you look at Right Honorable Chair, by inserting, there is already a C, meaning you are substituting. When you look at the bill, there is already a C. And then here, when you are amending, you are saying by inserting after B. Just in the bill, there is already
after
C.
1B, immediately you are inserting You do renumbering during the cleaning process.
Because, Chair, when you see there is already C.
Honorable, after we've done what we are doing, they are going to do the renumbering.
Thank you.
Yes.
I appreciate.
Limit on investments. You don't want A.
Yeah, because, Chair.
A mortgage refinance institution may invest in treasury securities. Not so? So you're saying it should not invest on treasury securities?
Because, Madam Chair, when these companies come here, they might find these securities more attractive and more profitable compared to the mortgage business, and end up channeling all their resources in our security market, knowing that it's very competitive. And that's why I do not see any reason as to why we leave that clause here. Madam Chair, we legislate for the future as well. Thank you.
Yes, Honourable Minister. I see the Honourable Member is speculative.
Is now trying to take us into the unknown. However, I don't see any harm because this is related business. It is not something outside the normal business mortgage refinancing institutions.
We can actually set in the regulations on the percentage of investment.
Yes. We can define the asset classes in the regulations and say...
We'll put it in the regulations on the percentage that you should not exceed this amount.
So I persuade you to agree with us and we move on.
Honorable Hassan, Adwam, Bedi.
Madam Chair, if it's going to be capped, then I consent.
We will for sure.
Madam Speaker, there's no way, Madam Chair, there's no way the mortgage refinance institution wouldn't invest in a treasury bill or bond. Why? Because they would be receiving the funds.
We've already made a ruling to that effect.
Yeah, they would be receiving the monies first before they provide it to the financial institutions that will be providing mortgages. So they pack that money first and then they can own land.
Thank you. I put a question that clause 15 be amended as proposed. Those in favor send the contrary nay. The ayes have it.
Clause 15 as amended.
I put a question that clause 15 as amended stands part of the bill. Those in favor send the contrary nay. The ayes have it.
Clause 16.
I put a question that clause 16 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 17.
17, Chair.
Madam Chair, clause 17 is about prohibited activities. Clause 17 is amended in subclause 1C by inserting immediately after the words Central Bank, the words, and in accordance with the Capital Markets Authority Act. Justification: the Capital Markets Authority was established under the Capital Markets Authority Act, CAP 64, to promote and facilitate the development of an orderly, fair, and efficient capital markets industry in Uganda. And as such, mortgage refinance institutions should conform to the law on the capital markets. I submit.
Minister.
I agree with the committee chair. We are already harmonized on this.
Okay. I put a question that clause 17 be amended as proposed. Those in favor say the contrary nay. The ayes have it.
Clause 17 as amended.
I put a question that clause 17 as amended stands part of the bill. Those in favor say the contrary nay. The ayes have it.
Clause 18.
Chair.
Madam Chair, clause 18 is about lending to primary mortgage lenders. Clause 18 is amended. A, in subclause 1, by deleting the word credit accommodation, or and B, by substituting for the subclause 3E the following: E, meets any other conditions set by the central bank and the underwriting standards set by the mortgage refinance institution under subsection 5. Justification: the word credit accommodation is used to define the word credit facility. As such, the use of the word credit facility in the provision caters for the word credit accommodation. And 2, to specify that the standards set by the mortgage refinance institution are the underwriting standards provided for under clause 4 subsection 2D and clause 18 subsection 5 of the bill.
Honorable Minister.
Madam Chair, I agree with the committee position.
I put a question that clause 18 be amended as proposed. Those in favor say the contrary, nay. The ayes have it.
Clause 18 as amended.
I put a question that clause 18 as amended stands part of the bill. Those in favor say aye, to the contrary, nay. The ayes have it.
Clause 19.
I put a question that clause 19 stands part of the bill. Those in favor say aye, to the contrary, nay. The ayes have it.
Clause 20.
Chair.
Madam Chair, clause 20 is about protection of collateral pledged to mortgage refinance institution. Clause 20 is amended by inserting immediately after subclause 3 the following: 4, where a primary mortgage lender defaults on its obligation to the mortgage refinance institution, the mortgage refinance institution shall attach, assign, or transfer the collateral pledged by the primary mortgage lender. 5, subsection 4, shall apply where the collateral pledged is owned by the primary mortgage lender. And 6, the central bank shall prescribe in a regulation the procedure for attachment, assignment, or transfer under subsection 3. Justification: the bill does not provide for the procedure of dealing with the collateral pledged where a primary mortgage lender defaults on its obligation.
Honorable Minister.
Madam Chair, I agree with the committee position.
I put a question that clause 20 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 20 as amended.
I put a question that clause 20 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 21.
I put a question that clause 21 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 22.
I put a question that clause 22 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 23.
I put a question that clause 23 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 24.
I put a question. You have amendment on 24?
24, yes. Madam Chair, clause 24 is on limit on shareholding. Clause 24 is amended by inserting immediately after subclause 1 the following: 2, a person, body corporate controlled by one person, group of related persons, or body corporate owned or controlled directly or indirectly by a group of related persons who intend to hold more than 10% of the shares of a mortgage refinance institution shall apply to the central bank for approval. Justification: to require the approval of the central bank once a person intends to hold more than 10% of the shares of a mortgage refinance institution.
Finance.
I agree.
I put a question that clause 24 be amended as proposed. Those in favor say on the contrary, nay. The ayes have it.
Clause 24 as amended.
I put a question that clause 24 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 25.
Chair.
Madam Chair, clause 25 is about power of the central bank to issue directives. Clause 25 is amended by substituting for subclause 2A to the following. Roman numeral 2, to put a limit on the nature of a mortgage refinance business which a licensed mortgage refinance institution can offer. Justification: to provide clarity that a limit will be placed on the nature of the mortgage refinance business.
Minister.
I agree, Madam Chair.
I put a question that clause 25 be amended as proposed. Those in favor send the contrary nay. The ayes have it.
Clause 25 as amended.
I put a question that clause 25 as amended stands part of the bill. Those in favor send the contrary nay. The ayes have it.
Clause 26.
I put a question that clause 26 stands part of the bill. Those in favor send the contrary nay. The ayes have it.
Clause 27.
Chair.
Madam Chair, clause 27 is about cessation of mortgage refinance business. Clause 27 is amended by inserting immediately after subclause 1 the following. 2. A mortgage refinance institution which intends to cease to conduct mortgage refinance business or Islamic mortgage refinance business shall, in writing, request for the approval of the central bank. Justification: to provide for a manner of request for approval of the central bank for cessation of mortgage refinance business by the mortgage refinance institution, which was not provided for under clause 27.
Minister.
Agreed.
I put a question that clause 27 be amended as proposed. Those in favor say on the contrary nay. The ayes have it.
Clause 27 as amended.
I put a question that clause 27 as amended stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 28.
28.
Madam Chair and colleagues, clause 28 is about insolvency of a mortgage refinance institution. Clause 28 is amended in subclause 2 by substituting for the words "its agent" the words "person appointed." Justification: clause 26 subsection 3 provides that the central bank may take over management of a mortgage refinance institution or appoint a person suitably qualified and competent, and does not provide for an agent.
Chair, finance.
Madam Chair, in my little commerce, entities are governed by a company, not individuals. Individuals cannot be liable when a business is collapsing because they are protected.
You can open the veil. You can lift the veil. You do not hide behind a company. If you want to hide behind a company, you lift the veil to go to individual owners. If you're a shareholder and we have failed to get what we want to get from the company, we will go for your personal belongings. Even in banking. Greenland Bank.
Concede.
Thank you.
Madam Chair, this is a harmonized position with the committee.
Thank you. I put the question that clause 28 be amended as proposed. Those in favor say on the contrary nay. The ayes have it.
Clause 28 as amended.
I put a question that clause 28 as amended stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 29.
I put a question that clause 29 stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 30.
I put a question that clause 30 stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 31.
I put a question that clause 31 stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 32.
I put a question that clause 32 stands part of the bill. Those in favor say on the contrary nay. The ayes have it.
Clause 33.
I put a question that clause 33 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 34.
I put a question that clause 34 stands part of the bill. Those in favor say on the contrary, nay. The ayes
Clause
have
35.
it. Clause 35.
Chair, right honorable Chair, 35 is on power to make regulations. Chair, I propose we make amendments and insert sub-clause 4 that regulations made under this section should be laid before Parliament by the minister responsible after gazettement. Should be anchored. It could be in rules, but should be anchored in the act or in the bill.
I agree.
But the rules are
Chair.
subordinate to the act. So
I
what
agree.
is suggesting is correct. Yes.
Thank you very much, Right Honourable Chair. Right Honourable Chair, the challenge with his proposal is that it be laid before this House after gazettement. Supposing they take forever to lay them. I mean to gazette them. So it also becomes a problem. So I think it is better to state that they should be laid in this House 6 months after assent. Within 6 months after assent. Yes. So that the moment the President has assented, then the Minister works on the regulations and ensures that the gazettement and all that is done, but they must be laid in the House within 6 months. Thank you.
I concur, Madam Chair.
I put a question that clause 35 be amended as proposed by the acting leader of opposition and amended by the Minister of Finance. Those in favor say on the contrary. Those in favor say on the contrary, nay. The ayes have it.
Clause 35 as amended.
I put a question that clause 35 as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Clause 36.
Clause 36. I put a question that clause 36 stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Schedule 1.
I put a question that the first schedule stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Schedule 2.
Schedule 2, Chair.
Madam Chair and colleagues, Schedule 2 is about criteria for determining whether a person is a fit and proper person to manage, control, become a director, or substantial shareholder in a mortgage refinance institution. We propose that we delete paragraph 1D. Justification: mortgage refinance institutions are barred from taking deposits under clause 17(1)(a). As such, the provision is redundant.
Honourable Minister.
Madam Chair, this is a straightforward proposal. I therefore agree.
I put a question that the second schedule be amended as proposed. Those in favor say on the contrary, nay. The ayes have
The
it.
second schedule as amended.
I put a question that the second schedule as amended stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Title.
I put a question that the title stands part of the bill. Those in favor say on the contrary, nay. The ayes have it.
Motion for resumption of the House.
Honourable Minister.
Madam Chair, I beg to move a motion that the House resumes and the Committee of the Whole House reports thereto.
I put a question that the House resumes and the Committee of the Whole House reports thereto. Those in favor say on the contrary, nay. The ayes have it.
Report of the Committee of the Whole House.
Honorable Minister.
Right Honorable Speaker, I beg to report that the Committee of the Whole House has considered the bill entitled the Mortgage Refinancing Bill and passed it with amendments.
Motion for adoption of the report of the Committee of the Whole House.
Honorable Minister.
Madam Speaker, I beg to move a motion that the report from the Committee of the Whole House be adopted.
I put a question that the report of the Committee of the Whole House be adopted by this House. Those in favor say on the contrary, nay. The ayes have it.
Bill's third reading, the Mortgage Refinance Institutions Bill 2025.
Honorable Minister.
Right Honorable Speaker, I beg to move a motion that the bill entitled the Mortgage Refinancing Institutions Bill 2025 be read for the third time and do pass.
I put a question that the Mortgage Refinance Institutions Bill 2025 be read a third time and do pass. Those in favor say on the contrary, nay. The ayes have it.
A bill for an act titled the Mortgage Refinance Institutions Act 2025.
Title settled and the bill has been passed. Congratulations, Honorable Minister. First, I want to thank Committee of Finance, the chairperson. You have not disturbed us with your bill. When we give you people bills, don't go and redraft. Put your own language in the bill. First, understand the motive, the object of the bill. You've done a good job. Thank you. And I want the legal person who worked on the bill, the evaluation bill. I want him in my office. Yes.
Madam Speaker, I want to, on behalf of the committee, I want to thank you for the observation and recommendation you made to the committee. And I want to thank my colleagues, the members of the Finance Committee and the technical team for a job well done. Thank you so much.
You're also thanking me for using his stick.
Madam,
on you.
Right Honorable Speaker, on behalf of the Ministry of Finance, Planning and Economic Development, I want to thank you for expeditiously considering this bill. And I want to thank the Committee on Finance for making a lot of effort and understanding our persuasion. Because, Madam Speaker, I wish to note that the bill we are considering is a new area which required all of us to take time to appreciate and understand, and the committee was able to give us an enabling environment to enable us move, and I appreciate them. Lastly, in thanking you and the committee, is that from our side as Ministry of Finance, we don't have pending business with the Committee on Finance. They have cleared all the business we have brought, and I really appreciate them for that.
Thank you. Thank you so much, Committee of Finance. I want to urge all the committees that have pending business to bring the business on the floor. Honorable Minister of Local Government will handle your document, your paper, first thing on Tuesday. House adjourned to 2 p.m. on Tuesday.